Good morning, ladies and gentlemen. Welcome to the 533rd Board meeting of the Central Valley Regional Water Quality Control Board, Central Valley Region. I would like to introduce the board members and staff at this time. On my far left is my good colleague, Carmen Ramirez of Atwater. Sitting next to Carmen is John Constantino of Grass Valley, and John, you're a good colleague too. but Carmen and I had an interesting experience yesterday. Sitting on my immediate left is Jenny Lester Moffett of Davis, and on my right is Bob Schneider of Davis. My name is Carl Longley of Fresno. Tam Dudek, state board member who is our liaison, planning on being in the audience, but a meeting was called in Bakersfield on a real important topic, fracking, and she's attending that meeting. And of course, this board meeting is being webcast to the public. I'll now introduce the executive officer, Pamela Creedon, who will introduce her staff.
Good morning, Dr. Longley and members of the board. Across the room from me is Ken Landau, Assistant Executive Officer in the Sacramento office, and next to Ken is David Koop, Senior Staff Counsel for the board. To my far right here is Patrick Palupa, Senior Staff Counsel for the board, and to Patrick's left is our newest staff counsel, and I want to call you Patrick, Andrew Dieringer. So he just joined us a couple of weeks ago, so we're happy to have him on board. Alex Mayer, as you know, went to a position in Department of Toxics and Substances Control. To my far left is Karen Lanfranchi Rizzardi, Executive Assistant for the board. And next to Karen is Andrew Altavote, Assistant Executive Officer in the Sacramento office. In the audience, we have Clint Snyder, Assistant Executive Officer in the Reading office. And Clay Rogers will be with us tomorrow, but he is in Bakersfield on the fracking item at the request of State Board. And we also have Linda Bracamonte, our newest Assistant Executive Officer, who replaced Richard Lankarovich. And we have David King, who's a brand new Staff Services Manager who replaced Linda in her role. So he's sitting in the audience. And a number of other staff are here with us today, too.
Thank you very much. And the new staff folks, either here at the board or in your new positions, we're glad to have you, and we look forward to working with you. At this point in time, I would like to ask Carmen to lead us in the Pledge of Allegiance.
Ready, salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. The first item on our agenda is to consider the minutes from the June 5th and 6th meeting of this year. Are there any comments on the minutes? If not, do I have a motion?
I'll move the minutes.
Bob's moved. Second?
I'll second.
John seconded. All in favor of approving the minutes, say so by saying aye. Opposed, say no. Abstentions?
I will abstain as I was not present for the meeting.
Thank you very much. So note, please, and that Carmen has abstained. That the motion passes. We'll move on in the agenda to item 2, which is the meeting procedures. In order to conduct our regional board meetings in a fair and efficient manner, we'll be proceeding in accordance with the meeting procedures that have been provided with a summary agenda and are available here at the staff table and upon requests, and are posted on the board's website and are summarized on the computer screens that you see during the breaks. Any questions or comments regarding these procedures may be directed to Karen Lanfranchi Rizzardi, the Administrative Assistant to the board. Thank you. Moving on to agenda item 3, are there any board communications? Yes, John.
Just to note that on Monday, this last Monday, I attended a multi-agency dam safety tour at the Argonaut mine, and nothing to report other than I got a tour of the facility.
Very good. Anything else to report?
Carl, I went on a Yolo County Board of Supervisors ag tour, some of the farms around Yolo County, and identified myself. I was there primarily representing the conservation organization I volunteer with in Woodland, but I also identified myself as a board member of the Central Valley Water Board. It was very interesting in terms of some of the items we've discussed before were reflected there, increasing groundwater pumping, primarily with the hardening of demand as we see a lot more planting of nut crops, almonds, walnuts, pistachios, and others. There's a lot of driving factor for almonds is where it used to be $1 a pound, it's now $3 a pound, and we're seeing a lot of, I think we're going to see some cultural changes in the Sacramento Valley as different people become players in the region. So I found it a informative tour. And that was on August 5th.
Just as a follow-up on that, I had a conversation the other day with Cindy Forbes, who's the new drinking water director. Cindy, by the way, is an alum from my college, and I've known Cindy for 30-some-odd years, but back from the times when she was a student. But Cindy's saying that they have, I think, $1.5 million funds for drinking water supplies that run into problems with water. Losing their water supplies, losing their wells, and that we're coming upon August and September, and experience shows that in August and September is when we really lose the hard rock wells. So this is not a good year. This is going to be a year that unfortunately is going to bring a lot of hardship unless we suddenly get rains, and I don't expect that to happen. Any further comments? Pamela and I had a very interesting tour about a week and a half ago. It was sponsored by the Sierra Fund, and it was to look at some activities that are going on the upper reaches of the Yuba. There is an area up there that they're working on. Among other things, they are working towards bringing in a process that pumps gravel and other materials out of reservoirs, runs it through a centrifuge, and reclaims the mercury and the trapped gold. Cleans up, allegedly, and this is going to be piloted to see if it works, and it won't be starting up for a few months. But allegedly, the gravel that comes out of this process is clean enough to be put into the river below the dams, so it can be part of the gravel replenishment program. And I'm interested to see the economics if behind some of these dams, if that process can be economically viable insofar as extracting gold and mercury and pay for itself in that manner while doing a great service, moving some of this material around the dam and maybe offsetting the need to truck gravel in as is now going on. And of course, gravel's being trucked in to provide materials for the redds where the salmon breed. Interesting, and we'll keep you up to date. There's obviously we want to follow up on this and see what their success is as it goes down the road, and once the demo starts up, I think that's something we'll be wanting to follow too. Any further comments? Rest of my activities will be in the written report that I provide for the minutes for the next meeting. With that, we will go on to item number 4. Karen, do we have any attendance cards? There are none. Is there anybody who wishes to address the board at this moment in any matter that is not before the board on today's agenda? Seeing none, we'll go on to item number 5. The executive officer's report. Is there any discussion?
I don't have any awards to present today. Tomorrow I will for staff. In following up of yesterday's hearing with the Senate Rules Committee, I just wanted to point out to the board every EO report we provide an enforcement action update.
Just to give context, yesterday, Carmen and I appeared in front of Senate Rules it was a confirmation hearing. And within a couple of weeks, we'll learn what the vote will be. They'll take a vote, I guess, in about 2 weeks.
But those who spoke in opposition challenged the board's enforcement actions, that we weren't tough enough on dischargers. So I just wanted to remind the board, I mean, we consistently have a high percentage rate of enforcement. We do take our orders seriously. I wish we could do more, but we are maxing out staff resources as I speak on trying to accomplish what we do, and we continually maintain a high level of enforcement activity. In this last report, just between April and June, we accounted for about 50% of all the enforcement actions, formal enforcement actions taken by the boards. So we're not sitting back and letting dischargers not be in non-compliance.
In the 2013-14 fiscal year, this board carried out 38% of all formal enforcement actions by all the state boards and 37% of the ACLs. I might also add that the group was critical specifically of Folsom and Colfax, and at this point in time we're continuing to address the Folsom issue. We cannot find anything to substantiate what is being stated by certain individuals as a problem in Folsom, but Pamela has asked the Office of Enforcement to independently investigate that to see if there is something we're missing. We're awaiting their input. And then finally, on Colfax, as I stated yesterday, certainly I consider Colfax to be a success story. They had some real issues. Starting back in 2007 was our first cease and desist order. We ultimately gave them the last of 4 cease and desist orders in 2013. They have completed all of those. This is a poor community. It's a disadvantaged community, and this was all taking place during the time that we were in a recession with much higher unemployment. The cities are suffering, and yet they came into compliance. And we consider this a success story, how we will work with dischargers if they're trying to achieve water quality to the maximum extent possible.
The other issue brought up was that board was accused of waiving their penalties, and clearly the board didn't waive the penalty. The water code allows a certain percentage for disadvantaged communities, provide for those penalties that we assess to be paid for in a compliance project, and they qualified for that, and so we didn't waive or forgive the penalty. They were simply allowed to put that money into the compliance project that would allow them to upgrade their facility as required by our order. I mean, our order didn't require upgrades, but our requirements of the order resulted in an upgrade to the facility.
This region has, by the largest number of disadvantaged community of any region in the state, and in fact it's one of the poorest parts of this region, are some of the poorest areas in the United States. And I cannot understand a philosophy where we don't work with these communities for them to stay in compliance, that we're supposed to basically take them out of existence by fining them into the ground. It just doesn't make any sense to me. But this seems to be what some people feel we should be doing, and we'll see what happens at the end of the day.
And I'd like to say that although I understand the need to enforce the laws, and that's certainly what we're here to do, I do want to go on the record as someone who cares about progressive enforcement. When an entity or a city or someone is trying to comply, we want to work with you. And I liken this to me as an attorney in civil practice. If we can settle the case, we want to. As long as there's no threat to human health, things like that, we want to settle. But if it takes an enforcement action and we have to litigate the matter, then we will. but we want to make sure that everyone knows that the door is open and staff is open to discuss issues that can be resolved before they come to the board. So we're open to that, but if that doesn't work, then we're here to do our jobs.
So, thank you.
Carl?
Yes.
Pamela, on the plans and permitting section, there's the mercury offset policy, and I can understand suspended, and I understand the need for prioritizing, but I am interested in this project. And
Which, I'm sorry, which?
it's the mercury offset policy.
Oh, yes.
So the word indefinitely I find
Oh.
difficult. It's
Oh, the state board,
it's on page 46 at the bottom of that page. Is that the state board then?
That's a state board effort. You're referring to the plans and policies. I'm
Right.
sorry, I was trying to. Yeah, that was something they were putting together when we were doing the TMDL for the mercury.
Exactly.
And I can check on that with Vicky to determine what the status is and why it was suspended indefinitely. Those are updates made by state board staff.
Yeah.
So
If you-
I'll check
thank
into
you
that
very
for you.
much.
Any further comments on the executive officer's report? If not, then we'll go to item number 6. At this time, we will receive a status report on the budgetary processing and control systems used by the water boards. This is an information item only, and no action will be taken, although the board may ask questions regarding the presentations. Following the presentation, interested parties will be allowed 3 minutes each to address the board. We'll now begin with the presentation.
So, Dr. Longley, I'd like to introduce this. This item was put on the agenda at the request of Member Schneider. Our things have changed in the state board on how they allocate budget resources to the regional board in terms of personnel services, and that's kind of changed how we've been reporting it. We used to have to be very detailed and extremely accountable for making sure we stayed within the dollars and PYs that the state board allocated to us. A couple of years ago, that process has changed. So I've asked Bill Damien, who's Assistant Deputy Director for the Department of Administrative Services at State Board, to present to you on what those changes are and what the responsibilities of the regional board are now for being accountable for the use of personnel services and operational expenses as well. So Bill?
Good morning, Board. As Pamela said, my name is Bill Damian. I'm the Assistant Deputy for Admin at the State Board. Thank you for having me. Hopefully I can clarify a few of the concerns on what's been changing with the budget over the past couple of years. There's 2 main factors that have changed how we're reporting and providing allocations to the regional boards and the other organizations at the State Board. Primarily, one is the new fiscal system that the Department of Finance has been working on, and they're looking to start implementing it this year. But over the past 2 years, we've been aware of kind of the things that were going to change, so we were trying to be proactive to manage our budgets throughout the state and kind of meld them to this new method, which is quite different from what we've done in the past, which is detailed allocations, detailed expenditure reporting, looking at each organization and region and making sure they're on track, whereas Fiscal is looking at the State Water Board, one huge budget entity. The other reason we were making some of these changes is really duplication of effort. All of the regional boards and the organizations at the State Board were tracking their budget, spending a lot of time, on various systems, monitoring. We were doing the same thing in the Division of Administrative Services. We'd coordinate, we'd make adjustments, but ultimately it's our reporting that goes to finance, and it's typically at the appropriation. So we're tracking all this low-level expenditure detail when what's really required is just the appropriation, so it's everything rolled up into one. So that's partly why we've made this change. I think the biggest change, and I've not seen one of your reports, but I understand it was quite detailed, is there's various line items that we now consolidate statewide, And we've historically never, fully spent, such as travel and training. So they're now managed as a pool. So those line items are no longer the responsibility of any of the regional boards or the organizations. In addition, facility operations, communications, and a few other small line items. What the regional boards and the state board organizations are responsible for are various contracts that they have in place, whether it be kind of statewide contracts that they have a piece of, or what we call the discretionary contracts. Each year, all of the assistant executive officers and the assistant deputy directors get together. They come up with a list of priorities. There's a thoughtful process looking to identify, what's the highest priority, how much money do we have, and then we fund them in according to the funding availability, and the priority of the projects. That then goes to the MCC, which is the executive officers and the executive director, for final decisions. So those are pieces that you will see in your Region 5 budget that you manage. In addition, each organization gets around, I think, $1,000 to $1,300 per position for all of your general expenses, printing, paper, supplies, things like that. So those pieces are still managed at the regional board and the organization level. What we've done with staffing, which is the biggest change, was primarily to help us as we transition to fiscal. What finance is doing now is every position is assigned a fund source. In the past, we had fund allocations, positions. They weren't necessarily tied, so a person might be charging 20 different funds depending on the work they're doing. What we're looking at is working with all the organizations and regions, trying to best allocate or tie the funds to specific positions. So we may have some engineers that are primarily NPDS and stormwater. That's the same funding source. So we kind of preset, this is the majority of their activities. So ultimately what happens is each month staff charge their time, it hits the appropriate fund sources, but all the regions and orgs really need to manage now is staffing. You have, I think Region 5 has 233 positions. We want to make sure those are full. So that's really the reporting we're looking at monthly, is how many positions are filled, what are your vacancies, can we get those filled as quickly as possible? Questions so far? I know I'm probably going fast.
Actually, it's 200, according to the numbers I have, it's 232.7 positions.
I round, we
So
round.
are we getting another 0.3 positions? I mean, how do you do that over different regions?
Sorry, we round in budget speak, and I thought I would go.
Sorry.
No, understand, but that's a good question. How do you allocate between regions?
Those are based on historic baseline and new resources. So I've been with the water board since '98. I could say Region 5 might have had 215 positions then. That stays baseline. We'd have reductions and then new BCPs add to it. So those are the only two ways that really increase or decrease the budget.
My memory's a bit foggy, but I kind of remember having 250 or 260 positions.
And there were huge cuts back
That's a
in
better
the early
baseline.
2000s.
Can we start with that?
But I didn't bring the detail. I'm no longer the budget
No,
officer.
I think it's a
so-
valid question. Can we start with 250 as a baseline?
Right. I think for now it's the 232. I actually, 0.7. Sorry, I have the detail report for this year.
We don't mean to be nasty to you. I'm sorry.
No, I'm.
Go ahead, please. That's very interesting.
So that's basically the biggest change. So I know what I report and what we usually report for all of the regional boards and the state board is the positions. We're managing the funds at one total for the most part. We're managing the travel. If we see there's a problem, we would notify areas if there is an issue. A certain organization might be taking more trips. A lot of things have been restricted in the past few years. We're still recovering from a lot of cuts. There used to be days when there was a lot of available funding. Now that's not so much the case. We're primarily fee funded, so most of the changes to those increase fees, which is always controversial. So bottom line is we're really trying to streamline the processes, have less of the tracking and detail that really isn't required done, so that staff can focus on other areas.
Linda, are you the staff person that handles this on a day-to-day basis? Could you come up, please? I'm sorry not to give you a warning ahead of time. How do you, how do you see, what does this do for your job? Can you explain that? This new system, does it make it easier for you to track? Can, or are there issues that you're facing here at the regional board level?
In all fairness, I think we used to have more ability to use our resources where we wanted to, because we had more flexibility, we had more control over different line items. So if we were having savings in personal services side, because perhaps we had vacancies sit longer than we would have anticipated, or turnover or whatever, close to year end we could look at moving some of those funds to maybe an equipment line item and replace our region with needs, fill our needs that way. With State Board assuming and consolidating a lot of these line items, we have lost that flexibility. However, I have to say, it's been a couple of years that we've been working under these new processes, and DAS has been accommodating that when we do need things like equipment, we submit our request, and they have met our needs. So we have less control, but our needs are still being met. I'm not sure I could answer to say it's easier. I feel right now, especially in, with Richard having left and me assuming this responsibility of maintaining or watching over how we are spending our resources, my goal right now is to make sure that what DAS says we have is what we really need. So I'm working on getting us in line that way.
I guess easier is the wrong word. What I was interested in is the time it requires for you to carry out your functions. Has that increased or decreased, or you don't know?
I think that remains to be seen. I am assuming the responsibility now that Richard has gone, and I haven't been in this position long enough to really see that through. But I would anticipate that it will be more efficient, because I will spend my time not on that lower level detail that Bill was mentioning. So I think it will be better in the long run.
That's interesting. Any questions? Go ahead.
Yeah, you were going to talk some more, Bill, first, or?
Actually, I'm trying to see what I had left.
But let me, I asked this agenda to be, or item to be put on the agenda, because, I'd been here a year and we hadn't heard too much about the budget, although I appreciate the reporting that's in the executive officer's report. And when I look at this, it is interesting, because you spoke to this, Linda, that we're going to have significant savings in personnel services, and it looks like about $2 million, somewhere in that range. So I'd rather not have that money and have the 10 positions filled, if we can head in that direction. But I guess I asked that partly, like, I know a lot of the other board members, the newer folks, haven't been through a review of our budget. And some of the things I'm looking for is just a review of the numbers that we see in the report a little bit, where we put our priorities. But ultimately, what I'm looking at is what is my responsibility as a board member to the budget. And I know we don't necessarily directly have responsibilities. We delegate those to our executive officer, and the state board has clearly assumed a lot of those responsibilities. But I do think as a board, just in good prudence, we have an obligation to periodically ensure that our funds are spent as wisely and as effectively as possible, and that's why I put them on here. So as we're hearing these reports, response to those kinds of questions are something that that help me. So go ahead, thank you.
Well, and we could definitely work with the regional staff to maybe come up with a way to report some information that's kind of a balance that will help you, because ultimately the budget is reported at the state board level, and they're fully responsible, is why we've kind of consolidated more things to make less work. And then you just have your programs and your positions, and if those are filled 100%, ideally, you're doing everything that, you have the resources to do.
That's correct. And if we have salary savings, principally because we have unfilled positions, doesn't mean we don't have the demand for those positions, the need for those positions. And if the executive officer, in her wisdom, can find ways to fulfill part of that mission through contracts or something else, we would certainly like to have those funds available for however she determines they might best be used.
Yeah, and I think typically salary savings is, at the end of the year, we estimate what the amount is, and then the state board looks at the priorities. Sometimes we'll even fund more of these discretionary projects as the money becomes available. We also do have some savings, like I said, with the waste discharge permit fund. We try not to spend it fully because if we have savings, then in the next year, the balance is higher and we have to charge, slightly lower fees. We don't have to increase them as much.
So, what I hear you saying is, I'm gonna perhaps put our board down a little bit, but I'm liking it to an allowance that a parent would give a child, and the regional boards are each children, and not to indicate that at all, but if the state board is a parent, and before the state board would give, let's say, a $10 a week allowance to the children, and now the parents or the state board is deciding what, if there is any extra money left over, is important. I'm wondering, as a result of that, does that mean that the loudest child or the loudest regional board gets a larger share of that money that perhaps had gone to other regional boards?
I don't believe so. I think at the MCC meetings that they do talk about if there is savings, so I believe it's discussed. It's not just, given out without a lot of thought put into it. So when the budget office comes up with, here's our projected savings, it usually goes to the executive director, and they look at various priorities statewide.
But it could be that some boards who might be more vocal about certain projects might get funding over that would have normally gone to a different regional board.
It's possible.
Quite frankly, to be very honest, I prefer the aspects of the old way. Maybe centralized reporting is good, but I'd like to see a lot more control over our funding, as we had in the past, as opposed to now. Any further? And I like your analogy. It is so fitting sometimes.
So,
Yes, John, go ahead.
so my thanks for the report. I mean, I've heard about fiscal and other aspects, and it's interesting to see how it affects the water boards. And I was pleased to hear Linda's view that we're getting what we need. I agree with Robert that Bob that part of our job is to make sure funds are spent prudently, and that if there's a priority assessment needed, that the board has that ability. But also, I think one of our main jobs is to ensure that the funds are there. And if they're not, then if we need to, as a board, step up and say we need something else. Knowing that is helpful. I know when the marijuana growing positions came about, there was an issue as to how many how many staff went to the state versus the regional board, and I was able to make a call and sort of walk through that issue to make sure everything was the way that should have been. And so those are kind of issues that I think the board, it's not something we deal with often enough, is the resources side of things, and I think it's key that we understand what's needed and make sure that we get it. So my question, I guess, would be to Pamela or Linda is, this new system, practically speaking, if there's an issue, certainly let us know about it. But and then my question, I guess, is, I think the word was, there's a travel pool and things are approved. Do we lose any of our autonomy on approving travel and that type of thing, or is that still?
Well, under this administration, travel still is, much as the travel is still subject to certain levels of approval at the governor's executive order about travel. So, but typically, travel, we have an amount for travel, and we're allowed to do that for training and travel. And so it just depends on what the event or venue happens to be and what level of approval needs to be done. But that's only been in effect with this administration.
And I get that there's always out-of-state travel restrictions and things that come down from the administration, but I guess my question is, if somebody needs to go somewhere and it's within the state guidelines, who makes that approval? Do we?
Well, we do. It all depends on what the venue is.
Okay.
And so, with a conference and other things like that, we do have to still seek approval from above, only because that's the executive order to do so. We didn't do that before. So we usually get that discretion on choosing the staff. Out-of-state travel, of course, goes all the way up to the governor's office for any approval. In terms of resources and the request for resources, I mean, where this hit us the most is at the end of the year. If we had personnel services, we used to be able to have some say over that savings on what could be done. Now that goes into a bigger pot that goes through our assistant executive officers meet, and they go through, everyone puts their wish list, their projects into a wish list, goes through a process that's vetted through the assistant executive officers to come up with their list that they recommend approval. It ultimately goes through Tom Howard at the state board, and he's the ultimate say if whether it's okay or not. It does come to the MCC, but Tom gets the ultimate say. So that was a loss on our part. We had a little more money since we're a big region and we had savings. We try very, very hard to keep our positions filled, but with being where we are, we've got a lot of opportunities for staff in other state agencies. So we have a good turnaround, a frequent turnaround, because the staff move in and out of the office. It's just unique to this office. You wouldn't see that in Region 3 or Region 1 that have fewer opportunities. But that's okay. That's okay. It's just what it is, and it tends to make it so that we have a higher rate of vacancies sometimes than other regional boards. So we're trying to work within the system. I agree with you. It feels a lot like the parent has taken back the reins. But in the executive director's defense at the state board, he's the one who's ultimately responsible, and he's the one who will ultimately lose his job if he doesn't properly account for the budget. So I can understand his concern.
Thank you for being here. And I kind of, having that centralized at the states in terms of fiscal accountability is kind of necessary probably in this day and age, so that it is what it is, and it's the communication between, your office and Linda's office, I think, is what makes things really work well. So we appreciate the support of everybody towards that good level of communication. I do want to also note that we hired 2 engineering geologists. I think that's a great trend.
Well, I'm not so sure I agree with that.
Yeah, maybe we should hire more lawyers.
I also note that we had 2 separations and 3 hires, so in another 10 meetings we'll be full up. So I do want to say that I don't really want to set well, I'm a board member, I could, so if there's some savings, maybe we should think about kicking off this mercury offset policy and moving that up a bit and get it off the suspended indefinitely list.
Yes, and I have to concur with all Bob's comments except for the comment on engineering geologists, but the geologists are essential. But seriously, my concern goes back to the loss of flexibility, but as has been pointed out, it's essential that we do centralize. I'm glad to hear that it's working well. I hope that continues. I hope we have the safeguards in place that it continues. My concern is not today. My concern is 5-10 years from now as this thing progresses, and I hope that we can continue to make it work.
I'm hopeful as well, and even with filling positions, we're looking at options to ensure that positions are filled as quickly as possible. So
appreciate that.
That's kind of the
Thank
next
you.
step.
Any further comments?
I would like to point out that Tom Howard, the executive director at the state board, has been very generous to Region 5 in the last few go-arounds with resources. So he appreciates the size of our region and the amount of work we have. But in fairness to the other EOs, there's a big fight usually over the resources because we all would like more resources. So it's a tough job. He has a tough job having to say no to some EOs and saying yes to others. That's a good job, but someone has to lose in order for someone to get, and
Exactly.
That's a tough decision to
Exactly.
make.
Understand that. Thank you very much for a very important report, and we'll probably be wanting you to come back in the future and give us some updates.
Thanks. It was nice meeting you.
Thank you. At this point, before we go into the next item, we're going to take about a 7-minute break. Try to be back here at 9:20. We're back in session. This is the time and place for a public hearing to reconsider a cleanup and abatement order issued by the executive officer regarding the Mount Diablo mine in Contra Costa County. The designated parties for this proceeding are as follows: the board's prosecution team, Sunoco Inc., and Kennametal Inc. All other parties are considered interested persons. The prosecution team has a combined total of 60 minutes for direct testimony, cross-examination, and a closing statement. Sunico and Kinnamantle shall each have a total of 30 minutes for the same. Interested persons shall limit their comments to 3 minutes. Pursuant to Government Code Section 11126C3, please note that the board may meet in closed session to deliberate on a decision to be reached based upon evidence introduced in a hearing. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear that testimony you are about to give is the truth? If so, answer, I do. Thank you. This time, evidence should be introduced on whether Sunico Inc. and/or Kinnamantle Inc. should be named as responsible parties under the cleanup and abatement order. The order of this hearing is as follows: testimony and cross-examination of the prosecution team, testimony and cross-examination of Sunico, testimony and cross-examination of Kinnamantle, comments by interested persons, closing statement by Kinnamantle, followed by closing statements from Sunico and the prosecution team. Please state your name, address, affiliation, and whether you have taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lanfranchi Rizzardi. She's sitting over here to my right. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
Dr. Longley, for the benefit of other board members and the public, I'd like to bring folks to the attention of a ruling that the board chair issued at about 5 o'clock last night, and that will help to provide a roadmap for the particular hearing moving forward today. And the gist of the board chair's ruling is essentially to allow the hearing to move forward, to allow for legal argument and testimony, except in considering one of the 4 general exceptions to the general rule that a corporate entity that acquires a subsidiary does not assume the liabilities of that particular entity. And there are 4 generally recognized exceptions. I think the parties are in agreement on that particular issue. The issue came up in the context of some rebuttal evidence that was submitted and some disagreement among the designated parties concerning how that particular evidence may be used. And so for purposes of the hearing, again, moving forward, the board will go ahead, open the hearing, take evidence, legal argument on the issues except for the legal theory pertaining to the assumption of liabilities. My suggestion would be that then the board would close the hearing on those except for the assumption of liabilities issue. A new hearing procedure would be proposed by the prosecution team in consultation with the designated parties, and the matter would be continued to consider the assumption of liabilities piece at a future board meeting, preferably the October board meeting.
Thank you very much. Does anybody have questions of our counsel? Do you have any further information for the board, David?
Nothing at this time.
Thank you. Are there any procedural issues that the designated parties would like to raise?
Yes, Chair Longley. My name is David Boyers. I'm counsel for the prosecution team. There are 3 issues that we would like to raise in advance of moving forward with the hearing. I would ask that you hear us out on all 3 issues before making any determination. The first is based on yesterday's ruling regarding the use of the interrogatories that the prosecution team believes forms the basis for corporate succession liability for Sunoco. We would request that all legal argument concerning corporate succession be postponed until the second date of hearing on this matter. The reason is it makes more sense to hear the rules and the exceptions and all the evidence and argument related to those at one time. The second issue we would like to bring to your attention is the prosecution team would like to make a motion to remove Kennametal as a responsible party from the order. We would allow the other designated parties to respond prior to the second date of hearing to that motion. The third issue is we are prepared today to go forward with our evidence with regard to discharges associated to Cordero's operations and legal argument concerning joint and several liability. However, we would ask that the board consider whether it would be more appropriate to continue this matter in its entirety to a hearing date in the future. And that's all. Thanks.
Okay, I'll go ahead and rule on, I'll start backwards. I'll deny the motion that this hearing be continued forward. We will take testimony today. Your motion to remove Kennametal, what are the implications of that, counsel?
Dr. Longley, that's really subject to, there's an existing cleanup and abatement order out there that's been issued by the executive officer, and the board now is considering whether to reconsider the issuance of that particular order. And what I'm hearing from the prosecution team now is that essentially they want to drop Kennametal completely as a responsible party subject to the order. That's certainly within the board's discretion to drop Kennametal as a responsible party subject to the cleanup and abatement order. Whether you may want to hear testimony or evidence on that particular issue is certainly subject to your discretion. But I think in a particular case like that, there may be some benefit or value in seeing what a revised proposed order would look like if in fact Kennametal was to be removed as a responsible party subject to the cleanup order, so that the board, the parties, the general members of the public are sufficiently clear on what that specifically entails.
Thank you. I'm going to deny the motion at this time.
Hang on.
But just a second. But I will entertain it. I will entertain it if it's made again after we hear testimony. Yes, Bob.
I have a question. I mean, if the prosecution is asking that Kennametal to be removed, I mean, how are they going to move forward with the prosecution on that issue? I mean, we're kind of in a box there. 'Cause
well, I would like
they
to
can't very effectively argue against themselves.
I would like to hear more testimony from them before we make the motion. As pointed out, we need more information for me to rule on that.
I'm not convinced.
The board could decide that it doesn't at this particular time, based on the motion made by the prosecution team. It appears that if the position they're putting forward is to drop Kennametal as a responsible party subject to the cleanup and abatement order, the board could choose to defer testimony on that issue, take none at all, take the suggestion of the prosecution team and drop Kennametal as a party subject to the cleanup and abatement order, say, no, we don't want to accept your motion. We'd like to hear some more evidence specific to that issue. Obviously, I haven't been privy to discussions between the prosecution team and Kennametal. Certainly, those parties are very familiar with the record. But from my perspective, as an outsider, it's unprecedented, at least in my experience, that the prosecution team has come forward in any case, in any regional board that I've had the pleasure and privilege of serving, where they've specifically recommended dropping a particularly responsible party.
David?
I recognize that, but at the same time, I'm going, if in their professional judgment they're not ready to prosecute against Kennametal, how can we ask them to do that? I mean,
Well, they aren't required to do anything,
And-
Mr. Schneider. They may decide to put on no case at all.
Well, and
which very well make your decision as board members relatively easy.
well, and the other thing is that, even if they don't come forward and present a case against Kennametal, there's an existing order in place. So I think that we're entitled to see and hear evidence about whether or not we believe that there's enough evidence to change the order that's in place now. So even if prosecution team doesn't present any evidence, there's still a burden to convince us. And I think that Kennametal Council, I believe, is someone is here. I'm sure that they're going to try to persuade us. So I would rather hear the evidence. I'm surprised at the motion right now as well, but I'd like to go forward and hear the evidence.
Well, that's fine. I'm not going to push that point.
And we may well remove
We
it.
may well,
But
but-
I think that that's a decision to be made after we hear a little more.
Yeah, it's,
Yes, Mr. Boyers, go ahead.
I think before we hear from the designated parties, it makes sense to me to get a clarification on the effect of the existing proposed cleanup order. My understanding is that the cleanup order was issued, that the parties came to you and asked that you hold a hearing to reconsider it. At that time, my understanding would be that that order is not effective. It is proposed. The deadlines are not being met. The parties are not out there doing work. And, if we tried to bring an enforcement action saying you're violating a cleanup order, they would say, well, we've had no opportunity for a hearing. It's not effective. So I think that it makes sense to clarify whether that order is in effect before we move forward with the testimony.
Basically, I'm putting your motion in advance. It'll be reconsidered.
and I want to add, I understand too, there may be other designated parties in this that want Kennametal as part of this
Exactly.
action, so we'll hear that. And I do appreciate our staff uncovering every rock about who can be a designated party in
No,
these
no
efforts.
pun intended. We'll go back to your first one, and my notes aren't complete enough. You started by saying based upon the use of yesterday's ruling, and could you please repeat that?
Sure. Based on the ruling from yesterday, we would request that all legal argument concerning corporate successorship be delayed until the second day of hearing.
And counsel, could you please advise? Excuse me.
I guess from my perspective in providing any advice to the board, I'd like to understand the basis for the party's position for seeking to delay. It's my understanding that the prosecution team has briefed at least 2 exceptions to the general rule, those being de facto merger and alter ego. What I'm hearing now is that using that word corporate successorship very broadly would appear to encompass all 4 of those exceptions. So essentially what I think I'm hearing from prosecution team counsel is essentially the only thing that that we want the board to take evidence and testimony on today pertains to some of the other, I don't want to say lesser issues, but more peripheral issues pertaining to the proceeding, namely, the statute of limitations argument that's been raised in the briefing, the issue about the application of Nevada law, those kinds of issues. So, it'd be helpful to get some clarification in that context before I provide any.
This is Julie
assistance to the board.
Macedo, Senior Staff Counsel for the prosecution team, and I'll try to give clarification for Mr. Coop to provide a ruling. And I appreciate the ruling that you issued yesterday, and I certainly understand the basis of it. And it has led to some confusion in the sense that the prior ruling that would allow us to use the interrogatories form the basis for our PowerPoint presentation that was distributed and now is ready to go today. So to the extent that there's some confusion as to the documents we can use, but the words we can say, that leads to a little bit of uncertainty about what line we can cross in terms of following both orders. In terms of the extent of the corporate succession offer arguments, Mr. Boyers and I have been replaced as counsel. I think there were some scheduling conflicts with earlier counsel, and the papers may have confused two issues relating to corporate succession. One is the alter ego issue, and then the corporate succession issue. We have no intention of ever raising or putting forth a piercing the corporate veil or alter ego argument with regard to either Kennametal or Cordero. In terms of the corporate succession argument, we presented in our papers a de facto merger theory until we found a document that indicated that one theory was much more clear and fit one of the exceptions much more appropriately. The ruling would allow us to not discuss that today, but discuss it at a later time. So to the extent that we go over the general rule and exceptions, we would hate to do it today and say, here's the document, we may not be allowed to use those slides at all. Instead, we'll discuss this rule and the exceptions at a later time. The context of our presentation today would be the discharges, the mining history, the intent and requirements of the cleanup and abatement order. It would allow Mr. Atkinson, as the expert staff member who's worked on this site for more than 12 years, to be deposed by both Kennametal and Sunoco counsel who are here. And then it would delay just the legal issues in terms of corporate succession, as that term is broadly used, because there's a leading case in California that says 4 exceptions, and whatever exception applies most accurately. And then we're happy to alert the parties that piercing the corporate veil is not something we intend to pursue, even though it was briefed in our papers.
May I ask one clarifying question, Dr. Longley? So is the prosecution team prepared to move forward at this time pertaining to de facto merger, or is the idea that for purposes of economy, efficiency and economy, that it would be best to include legal argument and testimony on that particular issue in conjunction with anything pertaining to assumption of liabilities, and bring those two arguments forward at a subsequent board meeting?
We think it's best to deal with it at the subsequent hearing.
If I may speak.
Just a moment, please. Okay. Okay. Good. Introduce yourself, sir.
My name is Adam Boss. I'm an attorney with the Edgecombe Law Group. I'm also counsel for Sunoco. I have with me today in-house counsel Kevin Dunleavy. He's come here from Philadelphia to be present here for this hearing. We object to the prosecution team's request to postpone all legal theories until a later date. I think this hearing has been postponed 3 times. The de facto merger argument has been in existence for many months now, and the prosecution team counsel has essentially admitted today that they are prepared to move forward with the de facto merger argument, but what they would like is to have more time to create and build a larger argument about all 4 exceptions, and we object to that. It's procedurally improper, and the board chair has already ruled that the limited assumption of liability exception is going to be pushed, and the de facto merger argument moves forward today. And we accept that ruling, and we also have not objected, again, to the board chair's ruling that the evidence they speak of be used. That was a ruling that was made, I think, a week ago, and that ruling has not changed. So we do not believe that there's any prejudice to the prosecution team, and what this request truly is just a request for more time, and they've had a significant amount of time. In addition, we've let the board know, and we've also let the prosecution team know that Sunoco today is going to move forward with its legal arguments. And the technical arguments that the prosecution team counsel just referenced, we're largely going to rest on our papers in relation to those arguments. So essentially what they're saying is that they'd like to put their case on, and I'll stand up and I'll give a 2 or 3 minute speech about what we believe about the technical arguments, and I'll rest on our papers, and I also believe that that is unfair. So for these reasons, I request that you overrule and deny her request.
Thank you. Do you have any further issues? Thank you.
I have a question of the prosecution team. The presentation that you're going forward with today, or the documents that we have here, is there information in here that has now been excluded by the chair?
And I guess I would ask Mr. Coop to clarify, because it's my understanding that based on the ruling of a week ago, I can use the documents, but based on the ruling from yesterday, I may have to change some of the text. So you may not have my presentation, what I plan to say, but I believe the slides would be acceptable for you to have.
I obviously haven't seen what the prosecution team plans to present in terms of a presentation. In order to provide some clarification on the ruling that the board chair provided, the board chair did allow for the interrogatories to come in, in response to a claim, as I understood it from the prosecution team, that evidence be admitted for purposes of rebuttal to rebut a specific statement that basically Sunoco's argument that essentially they did not assume the assets and liabilities of Cordova Mining Company, and to the extent that it's offered in rebuttal for that specific purpose, then the evidence could be used. Now, the board chair also ruled to continue the hearing to a future board meeting to consider additional evidence and legal argument pertaining to the assumption of liability as exception. And those interrogatories very well may be evidence that the board would consider at a future meeting concerning the assumption of liabilities portion of the hearing.
Yes, sir.
Mr. Chairman, my name is Chris Sanders, and I represent Kennametal Inc. I'm trying to, I'm shocked but pleased, but I'm trying to understand exactly the procedural aspect of this. The board chair with the advisory team has made a ruling that the regional board has the burden of proof to prove by a preponderance of evidence at this hearing that Kennametal is responsible and is appropriately named a discharger. If the prosecution team is not going to move forward with any evidence, that in itself is a decision then that they don't have the preponderance, they have the burden, and so Kennametal must be removed at that point.
But we do have written submissions
Yeah.
by the prosecution team. So just because they don't present a case personally today doesn't mean that we don't have their evidence and their position to have reviewed already.
That may be the case, but and I'm not going to speak for the prosecution team, but I think that they may be willing to stipulate that there is no evidence in the record to move forward with an alter ego or a de facto merger argument.
Right, but that would be something that has not been said yet. So as of right now, we do have legal arguments where there's been a position submitted that the board has considered, that the board, I think, wishes to hear evidence on. So even if they just sat there silently in their chair as to the issue, there is a burden that has been presented. Whether that's enough to overcome the defense is certainly a legal issue. But I don't believe that, should they sit there quietly today, that they completely fail on their burden. So I guess I would say that I'll end there.
In reply to both Sunoco and Kennametal, and also to the first issue raised by the prosecution team, we will proceed based upon the ruling that was made yesterday late. And we will be considering later whether or not we will remove Kennametal based upon the evidence that we hear as we go through the hearing. Thank you.
So, can I ask a question of the advisory team? So, as a board member, what am I what are we going to end up with today? Is there a result, or are we just listening and any decision will be any decision delayed, or will we be making some sort of decision today?
I think the best thing to do for the purposes of this hearing, because the board chair has ruled to continue the hearing as it pertains to the assumption of liabilities, and because that's one of the 4 enumerated exceptions, I think it would be best. Certainly, the board members could go, on record without taking any particular action after hearing the evidence, or lack thereof concerning Kennametal as to whether, in fact, they ought to be a responsible party subject to the cleanup and abatement order. But my suggestion is that because for purposes of I think efficiency and economy, and I think for your benefit as board members, that the hearing should be, that you guys should not make a specific decision today on whether in fact Sunoco or Kennametal should be a responsible party subject to the cleanup and abatement order until such time as all the evidence has been submitted and the hearing's been closed, and the board can begin deliberations. Now, the way the hearing is structured, the board is essentially going to hear whatever evidence is out there that's been presented, that's part of the record, aside from the assumption of liabilities issue. And but I wouldn't recommend it at this time. At the end of the hearing, and that portion of the hearing closes, if the board is inclined not to name Kennametal as a responsible party subject to the cleanup and abatement order, my suggestion would be to wait again until the following hearing is conducted so that we can consider all those issues all at one time. It seems it's a fairly significant matter, and I think for purposes of a clean record, I'd like to have all the evidence out there and close the hearing on all the issues prior to the time that the board makes a decision to drop a particular responsible party.
I have a question.
Yes.
Specifically for the record, does the fact that we would hear testimony today on evidence and then come back, let's say at the next meeting, which I think is October, and there's that much of a gap between when we hear evidence and when we decide the second part of the evidence presented, does that gap then open up the board's decision to challenge any more than if we heard the evidence all in one day?
I can't speak for what possible legal theory or argument someone may choose to proffer in an effort to try and enlarge or seek to enlarge issues presented for the board's consideration. What I can say is that it is at least clear to me in my understanding of the record about the arguments that have been raised by the parties, and that for purposes of the hearing continuing, that the board chair's ruling was specific in taking legal argument and testimony specific to one of the 4 enumerated exceptions, that being the assumption of liabilities. And I think, again, absent extraordinary circumstances, I think that the board chair would likely rule, and I don't want to speak for him, but he would likely rule not to admit any additional legal evidence or testimony.
Ken Landau with the advisory team. In answer to your question, or at least some historical perspective, the board has in the past continued hearings for any number of reasons. The state board, particularly in water rights, will have hearings going on literally for months before they make a decision. So I'd say it more comes down to a matter of if the board is comfortable with the information they have, and certainly one of the things that we would work on as the advisory team is making sure that transcripts, the appropriate information is available for you to refresh your memory and things as needed.
Thank you, and that's what my question was whether the gap on its own was enough to prejudice a result. Sounds like no, but I think we will need to, anyways.
No, I just want to draw a differentiation. I mean, the state board is remunerated significantly to remember things like that over a 2-month period, and this board does not have that day-to-day interface. I mean, to try and remember the subtleties of a lot of discourse over 2 months is extremely difficult. And if we're going to have a review of all that information at the next meeting to bring everybody up to speed again, it's going to be just as in the weeds as we're going to get.
Well,
I'm going, why?
Yeah, but what I'd like to have is transcripts provided to the board members of today's proceedings. And I think that will certainly be more than sufficient to recount the results of today's proceedings.
If I may, this is Adam Boss again. I request the finality today. Sunoco believes that there should be a final decision on the de facto merger issue. The prosecution team is prepared to move forward today with that issue. And there are some legal theories behind successor liability in the 4 exceptions, but they're not very complex. We can move through those at the next hearing fairly quickly, I believe. And the board chair's ruling was that the de facto merger would be heard today and the assumption of liability would be heard at a later date. The belief is that if there's no finality to the de facto merger issue, then we risk moving forward in the next hearing, the prosecution team putting on additional evidence, whether over objection or not, that may or not influence this board in its decision on the specific de facto merger argument. So for the record, we would like finality on that issue.
Well, that's denied, but we will have due diligence that the next hearing is confined to simply that one item, and other new evidence will certainly not be admitted.
Dr. Longley, if I can
Yes.
ask one clarifying question, and probably I'm beating a dead horse. I've heard Mr. Boss say that the prosecution team is prepared today to move forward on a de facto merger theory, but I don't know if I specifically heard that from the prosecution team or whether in fact they are planning to bring that argument forth for the board's consideration. I heard we want to talk about the mining history and operation and things like that, but I don't know if I heard anything specifically that said that they were prepared and willing and ready to move forward today on the de facto merger issue.
This is Julie Macedo. Mr. Boyers asked for a bifurcation of the issues from the mining history and the evidence of discharges, and then a separation for the second day of hearing for the legal issues. To the extent that we've briefed de facto merger and piercing the corporate veil, I've admitted that there won't be any evidence regarding piercing the corporate veil for either Kennametal or Sunoco. In terms of the de facto merger, I am happy to put on the evidence that we have, including the interrogatories that were ruled to be used. I will modify my statements in according with yesterday's ruling, knowing that we are coming back and briefing that issue. I don't believe there can be any finality based on yesterday's ruling. So to the extent that the interrogatories will be presented, they are contained in the PowerPoint presentation that was presented to you. I have copies that everyone should have received or will receive. You're free to peruse those at your leisure. I think you'll find them significant and understand why both rulings were made by Mr. Longley and Mr. Coop. And then we'll make a conclusion at the end of the second hearing.
Let me jump in. I think the question was whether or not the prosecution team is ready to proceed on the legal theory, not whether or not the evidence is here. I mean, are you ready to proceed with your case on the issue mentioned by Mr. Coop?
I'm happy to proceed. I think you'll see that the evidence fits more neatly into a theory that Mr. Coop would like more briefing and to allow Sunoco more time.
Point of clarification for today's hearing, Sunoco will be seeking a ruling that the document discussed here, the interrogatory, is hearsay. Would we like to wait till the end of the hearing to have that argument, wait for our presentation, or would we like to raise that argument when the evidence is presented today?
Well, this is an intriguing discussion, and I hope that I'm able to properly follow it. The ruling that was made yesterday was made with the intent to provide justice for the conduct of this hearing and that folks were prepared. And we felt that because of some of the other late submissions that there wasn't sufficient time. And now am I hearing correctly that both parties that are, I should state, all parties to this are ready to go ahead?
Sunoco's prepared to move forward.
Yes. And what about the prosecution team?
The prosecution team is prepared to move forward with respect to the de facto theory on corporate succession. It's our intent to rest on the papers submitted on that issue.
So in other words, if I were to rule that we are going to finish up this hearing today, you would be prepared to present your case today. Is that correct?
On everything other than what's been continued, yes.
I'm talking about not continuing. I'm talking about going to.
Absolutely. Yeah. If you're willing to hear everything, legal argument and evidence today, we're prepared on that.
And I have to ask Ken.
But that would be a modification of yesterday's hearing.
That's correct.
Okay.
And
we would be fine with that.
I have to ask Kinnamantle.
Yeah.
We have no objection. Go on, Mike, please.
We have no objections, and actually, we would look forward to this case moving forward and being concluded today.
Thank you. And counsel, any advice?
Just so I'm clear on the scope of what's going on. So, is the board chair's ruling, is the suggestion that the board chair's ruling is going to be modified in some way, such that?
Yes, that's really my question to the parties.
Such that
if I would modify that ruling, would they be? Are they prepared to go ahead today?
Such that the board would be considering the assumption of liabilities argument today at this proceeding?
That's correct.
Okay, my understanding is based on an email that I received from Mr. Boss that Sunoco needed additional time in order to be able to research those issues and to come up with any evidence in response to those interrogatories that were submitted.
That's not what I'm hearing now from Sunoco.
My original objection was for clarification of the order so that we knew what we were walking into today and we understood what the prosecution team's arguments were, because up until just recently, the assumption of liability argument had never been made by the prosecution team. So we wanted to understand that. We have searched for documents. We have found a limited amount of documents. We could likely search for more, but we don't believe necessarily that would have any dramatic effect on this board's ruling, and quite frankly, we can search for those later if need be. But today, we would like to hear, we would like to also have it limited, however, to de facto merger and assumption of liability. And that's what the prosecution team has stated they're going to present, and that's what I'm willing to say today that we're prepared to defend. If there's anything beyond that, however, we're going to have to ask to postpone this.
Prosecution team reply?
I think you meant de facto merger and piercing the corporate veil as opposed to assumption of liability.
I mean the two exceptions to the general rule, assumption of liability and de facto merger.
Well, express assumption of liability, I'm happy to cover that today.
Okay, so this hearing today is going to be about express assumption of liability.
Express or implied is one of the exceptions.
Okay.
And de facto merger.
De facto merger.
I'm happy to conclude today.
Okay, and if we don't have the assumption of liability in the presentation today, I'll do it via oral argument, but whether or not additional briefing on this issue will matter in this case, I think it's at this point in time we're ready to move forward.
Just so I'm clear, I'd like an affirmative representation in the record that the parties are willing to move forward on the issue of assumption of liabilities in light of the hearing that the board chair made to continue the hearing on that specific issue.
We will move forward, but if the board chair rules against Sunoco, we may be presenting additional evidence at the state board level because we've only had 5 days to search. So what is the question here?
You've actually had 2.5 weeks. We brought the interrogatories to your attention when we moved to enter them into the record, and that ruling was made 2 weeks ago.
It sounds like they're looking for 2 bites at the apple, and if they're not willing to waive their concerns that were communicated by email.
Yes, go
So
ahead.
if
David.
I could make a suggestion, maybe I could suggest a recess for 5 or 10 minutes, and I could meet with both parties, and we can see if there's a way to hash this out. If not, then no, but at least it might warrant
Well,
some.
I'm very, and I'm willing to change my ruling from yesterday. If we can work through this and both sides feel that they have the opportunity to make their cases today, that's fine. And if we can work towards that, and if we can get the statements on the record that firm that agreement up, that would be fine too. And I will grant a 10-minute recess so that our council can work with you on that. Thank you.
And wait, before we do the recess, can I ask one question?
Sure, go ahead.
Is the issue at hand just Sunoco, or are we? Because I'm not clear whether or not there's two decisions to be made, or what happened with that first issue with Kennemetal.
I'm not entirely. Well, I think I don't want to speak for the prosecution team's perspective, but I think from the prosecution team's perspective, because we just heard this morning that Kennemetal is being dropped as a responsible party subject to the cleanup and abatement order, that the assumption of liabilities argument is specific to Sunoco only.
John, I suggest that maybe the answer to your question be somewhat delayed. Allow our council to work with the parties and come back and report to us and probably give you then a better answer. Thank you. We're in recess. We're back in session. Council, please advise.
Sure, Dr. Longley. If I mess this up, then I'm sure one of the parties is going to get up and vehemently oppose. But this is my understanding. I think an agreed upon path moving forward for purposes of this proceeding. The prosecution team has agreed not to use the interrogatories for purposes of this proceeding, and to use them solely for the purpose of the portion of the hearing that's been continued specific to the assumption of liabilities argument, and they are prepared to move forward today on de facto merger. They've requested some additional time to modify their presentation in light of what they've been willing to do in this particular situation. They've told me that they'd like about an hour to be able to do that. My suggestion is whether maybe there are other board items maybe that could be considered, and then we could bring this back later in the afternoon. But again, that's subject to your discretion.
Prosecution team, do you agree with?
Yes, that was an accurate description of what we agreed to and asked for.
Sonico? I'll consider the time. Certainly you'll get extra time.
Does this mean we're still not making any decisions at this point in time?
I think at this particular point in time, we should move on to another board item.
That's what I meant. What I meant was at the end of the day with this item, are you still recommending that we continue our decision-making process to the continued hearing?
I think for purposes of making a final decision on whether one or both parties ought to be named subject to the cleanup and abatement order at this time, my suggestion is unchanged, only in part because I think there, at least at this time, there may be more benefit and value to the board members to hear all the evidence prior to making any decision to drop a particular party subject to the order, whether it's Kennemetal or Sunoco.
Sunoco, is that your understanding of the discussion you had? Come to the mic, please.
Yeah, the discussion we had dealt with bifurcating the argument. Today will be assumption of, in 2 or 3 months, it'll be assumption of liability. Today will be the de facto merger. They'll present their evidence today about de facto merger. They will not be presenting evidence in 3 months regarding de facto merger. We'll deal with the assumption of liability issue at a later date, and that is the understanding of Sunoco.
Good. That clarifies that. Does that I know you wanted to wrap up today.
No, that's not true. If we're not gonna be hearing and making all the decisions until the next meeting, I'm very uncomfortable proceeding at this point in time. I mean, putting this together with, giving an hour to redo a testimony, and then we're gonna hear about other stuff later, and I'm not comfortable with this track at this point in time.
Well,
The only thing I still have a lot of concerns about is the prosecution team doesn't want to continue with can't remember Kennemetal. I mean, yeah, you can hear what the evidence was, but I assume we're all also going to hear why the evidence doesn't apply anymore. And I mean, where are we going to be after all that happens? I don't get that. But.
well, at point here, I have to make a ruling, so I'm not. We've heard from one board member who's uncomfortable with proceeding. I'd like to hear from the other board members.
Mr. Chair, if it might add some, I guess, understanding as to our intent, the prosecution team does not intend to present evidence with respect to discharges by Nevada Shelite or argument as to corporate succession for Kennemetal.
Thank you. Yes, if other board members could provide me some input of how comfortable or uncomfortable they are, I'd appreciate it.
I don't have an issue with going forward. I understand the issues raised by Bob, but I mean, I think that if we have an accurate transcript and record, I think that it wouldn't be hard for, at least for me personally, to go back and pick this up, especially assuming that all parties will adhere to the no new evidence on de facto merger after today. And I'd like to make sure that all parties abide by that. But having said that, part of what Member Schneider just said is that had to do with not being, he didn't say he wasn't happy, but that he was, I think, displeased about the decision not to pursue Kennemetal in this hearing. I think that it is important that if the prosecution team comes to a point where they think a certain position is non-defensible, that they don't waste our time and try to lead the board down a path that maybe they've decided is not viable. So I don't know if that's what's happening here, but I do think that prosecution team needs to have the flexibility and the authority to decide, what is legally tenable and what isn't. And it's unfortunate that it happens at this late a date, but I certainly don't fault them for coming to a legal conclusion based on the law.
Jenny?
This has been delayed at least a couple times, and so my inclination is to at least try to make some progress toward getting to some sort of resolution. However, that said, I understand and I hear Bob loud and clear as far as making sure that 2 months is a long time. A lot will happen in my life in 2 months, and my memory may not be of what happened today will not be as fresh as it would be if I received all the information in the same hearing. So I have a couple thoughts, but I also would like to, and then also delaying 2 months would allow perhaps us to see a more buttoned up ACL, or not ACL, cleanup and abatement order. What I'm wondering is if we delay for 2 months and hear the whole argument in 2 months, if then at that time the prosecution team would come out with a new cleanup and abatement order that may not include Kennemetals. So we don't even have to act on that part right now. That's one question. And then my other question, and it's probably not a possible, but if we do start hearing information now, is there a possibility that we can have a special hearing in a month just for this item only? So those are my two questions.
So I think in response to your first question, certainly the prosecution team is free to issue a proposed revised order for the board's consideration to all the parties, for the board's consideration at the future board meeting that specifically struck Kennemetal as a responsible party subject to the cleanup and abatement order. The devil, of course, is in the details, and we actually have to see what that language actually looks like before I could make any advice or recommendation to you all in that regard. In response to the second question, I'm going to defer to management and staff on that issue. I think that's more of an administrative issue concerning whether, in fact, time can be made available outside of the normal regular board meeting schedule process to schedule a hearing specific to this item.
And then, so Carl, you asked for thoughts. Obviously, folks are here to talk through this, and I don't want to unnecessarily delay what's been happening. If folks are ready to do it, then okay. But that being said, sort of winging it on the fly because we have to put, patch back together something because of rulings that happened a week ago last night, re-ruling this morning. I wouldn't want that to cause, the final decision to be to question that there wasn't due process. So, and then, the one time I was on a jury, my biggest complaint was by the time I figured out what the heck everything was going on, all the good stuff had been presented up front. And I would hate to bifurcate this because I'm not an attorney. I'm trying to track as best I can. But by the time we put all this together, if it sort of months go by and we have to reassemble it, that'd be my worry, is that it's not a cohesive thing. It's just a sort of this compilation, and then at the end of the day, we're asked to either reconsider, reissue, bifurcate two different entities. One goes one way, one goes the other. So that'd be my worry, is that it when I was reading through all this stuff, it's complicated, and to make it, it's complicated, and if it becomes more complicated, then that's to me a bad thing if we're making it worse. So I guess it's no real definitive answer whether I want to go forward today or not, but if folks are comfortable that things can happen in a reasonable manner and that we can pick it up next time, then I'm okay with going forward. But if we think it's going to be too much of a this way, that way, then I would recommend a delay.
Ken, your
My light's on.
your lights.
In regards to the suggestion of a special meeting, it's certainly possible. My understanding of where we would be going from here if we start the hearing today is that on the other corporate succession issue that I'm not going to try to say correctly, that there would need to be arguments submitted and then rebuttals to that, and that would need to be all done prior to putting an agenda together for a special meeting. As it is for the October meeting, which is 9 weeks away, we'd have about 2.5, 3 weeks for the initial submittals, another 2-3 weeks for the rebuttals, and then we're right at the deadline that we have to assemble the agenda for the October board meeting. So if we did hold a special meeting, it wouldn't be much sooner, or either that or we'd have to really truncate the amount of time given to the parties to put their information together, or you'd have to be receiving it just before the meeting. And I don't think any of those options would be good.
And I would be willing to have a special meeting on the Wednesday before our next board meeting if we need to do it. Because we're going to need time. It would be good to have just this item and get it all sorted out.
Well, it sounds like this item is going to be limited in scope. It sounds like it's already been, the scope has changed. I'm not in favor of a special meeting. I'd like to see this as part of a regular meeting. If it's next time, then it's next time. But, it takes a lot of effort for me to plan my life to get over here. So I'm willing to dedicate the time that it needs, but if there's any way to keep it within the regular schedule, I certainly prefer that.
Yeah, I would concur with that scheduling would probably, especially with Ken's note, I don't think there's a whole lot of advantage to a special meeting, even though I appreciate the thought that we got to get this sort of focused. But
At this time, the October board meeting does not seem overly full that we could not provide time for this.
Okay, so could board members give input on the simple question of to continue to the October board meeting or start today?
Even though I'm sympathetic to the man that came from Pennsylvania, I think that in the interest of justice, I would support continuing the hearing to October.
John?
Actually, I don't know.
I'll take that as an abstention. Jenny?
I'd like to see it continue to October. I agree with Carmen that, I do appreciate everyone's efforts and certainly acknowledge the financial commitment to all be here today. But it seems like if we continue it, then hopefully at that time we'll be much closer to a more buttoned up item at hand.
Bob?
Well, you've heard my concerns about Kennemetal, but aside from that, I'd say let's continue this.
Dr. Longley? The meeting we're talking about is Thursday and Friday, October 9th and 10th. It might be worth asking whether the parties are available at that time as opposed to having some other conflict.
They need to be available anyway. We're going to be continued.
Well, that's true. That's true.
But they only found out about that last night.
I presume that the parties will be available unless I hear otherwise. Okay, I have not heard that anybody's not available. Unless you can give me a sound legal argument why we shouldn't counsel, I am inclined to rule that we'll continue this to the next meeting.
No sound legal argument. It's
No
subject
sound
to
legal
discretion of the board chair and board members.
Now, there is only, before I continue it, please set forth, we are not going to accept anything else, except with, we might possibly get a new.
Except for legal argument and evidence pertaining to one of the 4 recognized exceptions under the more general theory of corporate successor liability. And that particular exception is specific to a parent that acquires the assets of a subsidiary, and if that parent specifically assumes explicitly or implicitly the assets and liabilities of that subsidiary, then it takes those particular assets and liabilities of the particular subsidiary. And I think the parties, based on the discussion I had with the parties offline, I think we're all in reasonable agreement on that particular issue. Now, this doesn't preclude, obviously, all the other evidence and testimony and arguments pertaining to de facto merger, which is still on the table, and all the other peripheral legal arguments that we haven't had any opportunity to talk about today, the technical issues, everything else. The only thing this leaves open is the idea, again, that additional evidence and legal argument can be taken, accepted specific to the issue of the assumption of liabilities.
And we might also see a modified cleanup and abatement order.
That's subject to the prosecution team's discretion in light,
We would
in
entertain.
part in light due to what we heard today, that they have chosen to drop Kennemetal as a responsible party
So
subject to the order.
You've heard the one exception. The second exception is we'll accept a modified cleanup and abatement order. Past that, can you suggest a timeline, counsel?
That's one of the aspects of your ruling that still remains has to do with the control of the parties in developing a hearing procedure subject to that will be submitted to the advisory team and issued in consultation with the board chair.
And the hearing procedure timelines for that?
Ken has already started to look at that as a remote possibility in case the issue came up. We'll have the parties propose what those particular dates are consistent with the hearing that I'm hearing will be scheduled for the October board meeting, and we can work backwards from that.
So our council has set forth the one the one constraint on. Secondly, we will accept a cleanup and abatement order, revised cleanup and abatement order, and third, we'll be working on the hearing procedure. Is there agreement on that?
Mr. Chair, this is David Boyers. If I might ask for clarification on, I guess, the scope of due process or comments in response to a revised cleanup and abatement order. When we're preparing our hearing procedures, is it your intent that we allow the designated parties and other interested persons to comment or provide argument on the proposed revisions to the cleanup order?
I think that is going to depend on what the nature and scope of the comments are.
Well,
If it's
it's pretty simple.
For example, if it was specifically limited to striking Kennemetal and Kennemetal only, I don't what paragraph it is, 18 or 19 or whichever it is, and whatever else may apply, you probably wouldn't get a lot of reaction from the other parties. But if there are other suggested proposed revisions, to the extent that they're consistent with, you know, what's been briefed and what's argued on what's been argued and what's in the record, you know, it's not unusual for a revised proposed order to go out and to allow parties
We're going to
comment
have
prior
to
to the
see
hearing.
the hearing procedure.
Right, we're
before
trying
we
to
make
look
that
out for all
decision.
parties, and what we mean by when we say if we, the prosecution team, intend to drop Kennemetal, Sunoco may have an objection to that. And so if Sunoco has additional evidence to put forth in the record, we would not have any objection to that. And so to the extent if we are going to consider that at a later hearing, we just want to raise that possibility because it has not been raised today. So we're trying to look out for all parties and possibilities.
And at this time, I have no idea
acceptable, right.
whether, you know, Sunoco would support dropping
No,
Kennemetal or
we
not.
have to see what happens and so on. But what you stated to me is acceptable. Well, with that understanding, I'll then rule that this is continued to the next meeting.
Dr.
and-
Longley, there's
yes.
someone at the podium.
Dr. Longley, if I may, just one specific request before you make your ruling. I actually have a prior commitment on the Thursday, October 9th, and I'm also out of the country until the 8th. And so if I can make a request that we just hear this on the 10th, that would be great for on behalf of
That
Kennemetal.
works. That works.
Thank you.
With all of that said, I will so rule that we continue this with based upon the various factors that have been discussed. This is a very exceptional item, and it has been continued since April, if I'm not mistaken.
It's been continued prior to April. So just by way of background, the board chair issued the reconsideration letter that was sent to State Board in response to the petitions was filed, I believe, it might be a year ago today, or tomorrow. Thank you.
So certainly, we have to put this to bed at the next meeting. And I'm going to be very reluctant to allow anything into the record other than what we've heard.
We appreciate that, and we were more concerned about getting it right than getting it done now. So we appreciate the rulings today.
Very good.
And I just want to say, delays like this don't mean progress isn't being made.
Now, anything beyond the sky falling, I might consider. Okay, with that said, we're ready to move on to agenda item late, which is at this time we will receive reports on the State Board's low threat closure policy for underground storage tanks and other similar circumstances. This is an information item only. and no action will be taken, although the board may ask questions regarding the presentations. Following the presentation, interested parties will be allowed 3 minutes each to address the board. We'll now begin with the presentations.
So Dr. Longley, I'll do a brief. Whenever you're ready.
Before we get started, and Mr. Paloopa is sitting up here. That's good. Can we do the closed session item today?
Absolutely. We can do both. I think David Coop has one as well.
Good.
I have one that'll only take about 5 minutes. I think Patrick's
We'll plan on doing them today. Thank you.
So Dr. Longley, if you're ready for this item, I'll introduce it.
Yeah, I'm ready to go. But
so this item, I requested that this item be put on the agenda for the board. We have a low-threat closure policy for underground storage tanks that was adopted by the state board a couple of years ago. I don't know the exact date, around 2010, 2011. And it specifically was written for to address underground storage tanks, and you'll hear more about what went into putting that policy together. And in that policy, in the findings section or in the provisions, I can't remember exact section, it references that it wasn't written for anything other than underground storage tanks, but where it's a petroleum-only spill, and it looks and acts like a petroleum cleanup site, with all the exception of it not being the source being the underground storage tank, that the criteria in the policy could be considered for early closure for other sites where it didn't originate from an underground storage tank. A couple of letters were sent out by our staff to individuals who were requesting at cleanup sites closure for the early closure policy to be considered for their sites, and we were denying that use of the policy. And it was brought to my attention because they petitioned up to me, the discharger, wanting it to be reconsidered. And in speaking with and looking at the policy and talking to State Board and others, it appears that it can be used. It doesn't directly apply, but it appears that it would, in certain circumstances, based on site-specific conditions, that it possibly could apply. And in talking to Vicki Whitney, who participated in that effort from the very beginning with State Board, who unfortunately she couldn't be here today, and in Kurt Birchtal, the executive officer of the Santa Ana Board, who was very engaged in the development of this policy, they both agree that this policy clearly could be applied to non-UST cases. But to me, it's not a staff decision. This is a policy level decision. And that's why I've asked us to bring it to you, to present the policy, the background of it, how it might apply, and then to seek your input. It seems reasonable to me that we should consider it, but I'm not making that call. I want the board to tell me whether we should or should not. I should let you know there are some of our staff who don't like this policy, and they clearly would not like to use it, even for underground storage tanks. So there is some controversy on the staff level on how this policy should apply. So, but that's not for them. This is a policy level, and I need to get some input from the board on how they wish us to proceed for non-UST cases. The State Board has spoken on the underground storage cases. It clearly applies there, and we have been using it, as you'll learn with Brian's presentation. It's just a focus on those where it's a non-UST case.
So, Pamela, are the folks that petitioned you in the room today?
I don't know,
Oh.
honestly.
Are you in?
I did
anybody
meet
here?
with them.
I have no cards, John.
Okay. All right.
So, so what we have, Vicki couldn't be here today, but fortunately we have Shala Fararnak. Sorry, I butchered her last name, from State Board, and she'll give the State Board presentation on the policy and the procedures and the process they went through to adopt it, and then we'll have Brian Newman with the underground storage tank provide his presentation on how our UST cases have been handled, and then Duncan Austin will provide a presentation on the cleanup sites. So with that.
Thank you.
Good morning, Chair Longley and members of the board. My name is Shala Farahnok, Assistant Deputy Director with the Division of Water Quality, and I oversee our groundwater branch. And as Pamela mentioned, Victoria Whitney, Deputy Director, was scheduled to have this item, and she sends her regrets for not being able to attend. But I'm pleased to have the opportunity to provide just a high-level perspective and our point regarding the policy, as well as some of the points that Pamela made. And following my presentation would be more technical, detailed discussion by the regional board staff that I'm sure they can address the specific questions. So I would just quickly, briefly provide a history of how we got to have the low-threat USD closure policy, how the policy has changed the way cases are looked for closure, and then application of the policy to non-USD cases. So why the policy? During the 2009 hearings, the state board heard extensively from stakeholders that the implementation of policy and determination of the closures by different regions and local agencies, local oversight programs, was inconsistent. And as a result of those hearings, the state board determined that there was a need for standardizing the implementation of the underground storage tank cleanup program while protecting human health and environment, and then recognizing the role of natural attenuation of petroleum hydrocarbons, which would also lead to allow us to use our limited resources for high priority cases. So State Water Board adopted Resolution 2009-0042, which basically directed staff to work on developing a low-threat closure policy that would identify the cases and include criteria that are protective of the public health. And they believe that would lead to a consistent implementation of the program, as well as efficiencies both within the cleanup program and the cleanup fund program. So the policy development actually was a 9-member stakeholder group that involved it. So it was a stakeholder-driven process. There were 2 regional boards that were present, part of the group. We had Sacramento County as a local oversight program participate, Orange County Water Agency as a water district, and we had representatives from WISPA and SIOMA, as well as non-government organizations and a lead consultant, USD consultant, that was the primary author. There were extensive internal and external stakeholder outreach that was actually held by the the stakeholder group, as well as by the state board as part of our board adoption process. Also, as required by law, the policy went through independent peer review. So policy was adopted on May 1st of 2012, and after filing, it became effective basically on August 17 of 2012. And it accomplished what was intended to do, which was establish a consistent statewide case closure criteria for low-threat petroleum USD sites. And the scope of the work, as is consistent with the definition of the underground storage tanks, is basically all petroleum USD sites that are subject to Chapter 6.7 and Title 23 of the regulations. So the benchmark of the policy, which would be an important consideration as you addressing the policy question that Pamela posed to the board, is that cases that meet general and media-specific criteria that are outlined in the policy pose a low threat to human health, safety, and environment. And they satisfy the case closure requirements of the Health and Safety Code, as well as they're consistent with the State Water Board Resolution 9249 that specifies the closure procedures for cleanup sites. So how did the policy change case closure? On the technical side of it, basically, it created a standardized USD cleanup case closure criteria statewide. It created a framework to determine if groundwater impacts would reach water quality objectives in a reasonable amount of time. for the first time actually established a statewide criteria for vapor intrusion as well as their direct contact and air exposures. And these are some of the areas that inconsistent decisions throughout the state had created concern by industry and stakeholders. No, if I skip the case. So just quickly, I don't intend to turn this into a discussion of the graph, but right now, this US EPA annually puts a progress report. And the progress report, this is a draft, has not been published yet, so it's the latest news. Basically, it shows that they're expecting that during the projected closures statewide are about 1,200 USD cases.
Sorry, can you go back one slide?
Let's see. Okay, I guess I missed that one. Yeah. Thank you. I thought so. So on the program benefits, the really important, as you know, deals with us as government agencies providing good service. It created a transparent decision-making process for site closures. As I would use that as an example, in the past, it's like driving through a city. You had to stop at each corner and ask for directions, and this actually sets you on a GPS where you know where you need to get. The caseworkers know where they need to get your case, and you as a responsible party know at what point, where are you aiming to achieve closure. It also followed up to adoption of the policy. The board also adopted an implementation plan. As part of that implementation plan, specific goals and targets were set. And the two important ones, one was that it asked all the regional boards and local agencies to go through all their cases and identify which ones would qualify for low threat closure policy. And we are happy to say that all agencies met that deadline. It was, I believe, within a year of adoption of the policy, and that was extensive work that the caseworkers put into this. It also asked them for cases that do not meet the low threat closure policy criteria to identify a path to closure. And what path to closure means is basically identify the impediments and what are the reasons that the site has not been closed. And again, create a path and series of actions that they need to do and boxes they need to check in order to get to a point where they could be considered for closure under the policy. And the other overall benefit for us is that it allows over time allows the agencies to focus their resources on a higher risk sites that pose an extensive threat to human and environment. Thank you for reminding me. It kind of felt awkward. And now I'm going back again. Okay. Now this thing quit on me. You know how to move? It's not good. Just move it there. Okay, here we are. So my intention on this to just mention how statewide our agencies have been very successful, both regional boards and local agencies closing the cases. In some cases, some of the local agency cases have been transferred to the regional boards as well. Okay, this thing is not cooperating. Okay. So as to the question of the policy for non-USD petroleum cases, as was stated, the policy does not specifically address non-USD petroleum release scenarios, and that was because that was not the scope of the work. And also up to this point, we haven't had petitions or the state board has not closed any non-USD petroleum cases based on the policy criteria. So that's kind of on just basically what the state is. But as was stated earlier, the policy makes a statement that if a non-USD petroleum site exhibits attributes similar to those in the policy, basically when the criteria for closure and evaluation of these non-USD sites should be similar to what's in the policy. So basically, you're dealing with the same contaminants, you're dealing with the same media, and in general, above ground storage tank cases are actually less complicated than the underground storage tank, because I used to work actually in the USD program initially. So when you're dealing with petroleum releases, you are arriving at a situation where plume is stable or declining, constituents do not pose a high risk, and then you meet the general and media-specific criteria that are outlined in the policy, and water quality objectives could be met within reasonable time. So that's really the underlying principle of the policy, and during the discussions through the stakeholder process, that was what was the focus. It was not necessarily whether the release was coming from an above-ground storage tank or underground storage tank. That's on the technical side. I'm taking that point. That's one? Just click the left button. That's what I did. It's not moving. Why don't you just move it? Sorry.
Just click the left button. Oops.
It's not responding.
It's not responding for
Yeah.
you.
Mouse
Okay.
is good. Guess that's it. I want to make sure I didn't. So I wanted to close just by one statement that underlying reason and the premise and the intent of the policy is that these sites have reached characteristics that make them appropriate for site closure. And by closing those sites, you still are able to meet water quality objectives, and the site conditions are protective of public health, safety, and environment. And in fact, because of that, there's only one special case scenario under which the policy specifically talks about restricted use. So that's kind of an overall high-level policy presentation that I wanted to make. And as I mentioned, my understanding that staff are going to be following with more detailed discussion of the policy as well as the state of the program for the Region 5. And thank you for your attention, and sorry for the technical glitch. It always makes it more interesting.
Thank you. That was interesting.
Good morning, Chairman Longley, members of the board. I'm Brian Newman. I'm the Underground Storage Tank Program Manager here in Region 5. You've just heard from Mrs. Faranock on the history and intent of the policy. I would like to quickly brief you on Region 5's implementation of the policy, our program, and then the results we've seen. So a little bit of setting the scene. So in Region 5, we are currently the lead on 600 underground storage tank cases. These cases are primarily petroleum fuel, like 95% of them, petroleum fuel, gasoline and diesel. There are a couple other non-chlorinated solvents, but think fuels. Of these cases, probably 80% of them are either current or former gas stations. The gas stations, for the most part, have 2 to 6 storage tanks. They're 5 to 12,000 gallons normally. They go up to 20,000, but those are rather rare because of the difficulty in bringing them into suburban areas and siting them and whatnot. So that's what our cases are today. When the program first started, we had many cases that were at homes or small businesses. These were either heating oil or back during the 70s, during the gas shortage for some of us, there were long lines, people didn't like that, so they installed small tanks, 500,000 gallons at their homes so they could avoid that. These have 99% of them have been cleaned up and closed, so that's really not part of our population at this time. So when you hear the term underground storage tank case or site, think your suburban gas station. That's going to be the most accurate vision. This is another representation of a release. In this diagram, the release is shown coming from the UST. In actuality, many of the cases, the release was in the piping. It's pressurized. There's lots of joints, so there would be leakage. The difference there is these tanks were buried in pits, and they were 5 to 10 feet across. So the release was deeper underground. A shallow release, such as from a pipeline that's only a foot or two down, there's more exposure routes that come into play, whether it's vapor intrusion or direct contact with that contaminated soil. So anyway, shown on this diagram, we have two of the exposure routes shown. One is the contaminated well, and so people consuming the water, showering in the water. The other shown is the vapor, and that can either be intrusion in indoor air or outdoor air. And but then we would, like I said, we would also have the direct contact, which we would evaluate. Prior to the policy, we would go through and we would evaluate all these exposure routes, site-specific, be very detailed. When's water quality objectives going to be met for a particular, for the water, for all the constituents, volatilization rates, things of that nature. What the policy did for us is it pretty much states the bioattenuation was the primary mechanism is not adequately accounted for. I mean, in the models, it's in there, but in the field, we are seeing much greater bioattenuation. I mean by that is naturally occurring bacteria consuming the fuels as a food and converting them basically to carbon dioxide and water. And so we would request documentation of all this occurring, sampling. And the policy said, there's enough evidence out there. We are just going to accept, or we believe that this occurs, and the documents support it. And so we're going to account for it and provide some consistency. As Ms. Faranock said, that determination was being made by each staff, 9 regional boards, 54 counties, multiple cities, so you had a whole bunch of interpretations. The policy consolidated and gave consistency as to how these would be evaluated. In developing the policy, though, the policy group, I was not on the policy group, I was on the preceding task force, which recommended the adoption of a policy, but that there were 8 general criteria in order for the policy to apply. These are: the unauthorized release is located within a service area of a public water system. The unauthorized release consists only of petroleum, so we're not dealing with any chlorinateds or metals, things of that nature, but just petroleum.
But that would include the normal constituents. In other words, you might have benzene. Is that correct?
Yes, it's the whole world of what we would call
Exactly.
petroleum
Good.
fuel.
Right.
And in addition to, Stoddard solvent and kerosene, jet fuels, things of that nature. That the release has been stopped. I mean, this is kind of basic. Don't want to, if the release is still occurring, all bets are off. Free product has been removed to the maximum extent practicable. This is because when we talk about free product, it's what you'll see is in wells usually, it's floats, and the gasoline or diesel that was released. Now it'll age over time, but it's still like your Italian dressing. It separates and the oil floats on top. A conceptual site model that assesses the nature, extent, and mobility of the release has been developed. This is so that we have an understanding. Yes, this is what our site is, and this is what we're making our decision upon. We know the extent of the plume or plumes, whether when you look at soil and vapor, we know concentrations, things of that nature. So it does require that there be the investigation of the site. Secondary source has been removed to the extent practicable. We have a free product, but we also have a lot of petroleum fuels will absorb to the soil. The higher the content, the carbon content in the soil, the more it absorbs. So it kind of holds it like a sponge and can, rainwater or something percolating through it, just like coffee grounds can pick it up and keep feeding the plume. So we want that secondary source removed to the extent practicable. Soil and groundwater has been tested for methyl tert butyl ether. This was oxygenate that was put in according to the Clean Air Act. California, we chose MTBE was the oxygenate of choice. Much more mobile and persistent in groundwater and the environment than the previous fuels. And so it was put specifically in the code that sites had to be sampled for MTBE. So this complies with that section of the code.
I question for you on this. This is, you're talking about the 8 criteria. And remember the previous one on the previous slide that talked about the normal constituents, petroleum, well,
this one, the
maybe
previous
prior
one?
to that, but it states that it has to consist of petroleum, and as we talked about the normal constituents. Would you consider MTBE, in other words, if it contains MTBE, is it within the scope of what's being accepted for low threat closure, or is it outside of that with the presence of MTBE?
Oh, no, it's definitely included in the low threat closure.
Okay.
What's also included, and I'm sorry I skipped it, it's petroleum fuel and what's in the industry may known as an additive. Put a Tiger in your tank. I mean, each company would have their own extra stuff. And so it's not in petroleum that comes out of the ground. It's a manufactured product, either a cleanser. Of course, we used to have tetraethyl lead. Then they had to have lead scavengers like EDB to take the lead out of the mufflers. Otherwise, you ended up with marbles of lead in your muffler. And they found out. So the additives are also included when we talk petroleum. I'm sorry. And so when a site meets those 8 general criteria, then there are media-specific criteria. I'm not going to go into all of these, but there are scenarios for groundwater based on plume length and concentrations. And basically, if you meet these different scenarios, and there's 4 of them, if you meet any one of those, you satisfy the groundwater criteria. Vapor intrusion to indoor air. Again, these are concentrations that we can look up based on depth. And then direct contact with the soil or outdoor air exposure. Again, there's a whole bunch of models out there, predictive models, and what we found was that they are too conservative. They assume, or they predict more contaminants will be seen in the vapor because they don't account enough for biodegradation. So what the framers of the policy did is they said, we're going to do those calculations because there's a whole lot of variables that you can plug into these models, and it changes the results quite a bit. So the framers of the policy said, these are the ones we're going to put in, conservative in our opinion, and if it meets it, you guys don't need to go through all your modeling for each individual site. These criteria are sufficient. The policy was adopted in May of 2012. and became effective in August of 2012. That was due to legal review and everything. And to ensure the compliance with the policy, the resolution that adopted it in May required certain actions. The first was that all sites within open sites were to be reviewed within 1 year to the criteria in the policy. This is proactive to make sure, and this is both the regions and the local agencies were to do this review. And to track it, they added some pages into GeoTracker. GeoTracker is a statewide database maintained by the state board and their contractor. It's there's two sides of it. There's a regulator side that we work in and we put things, and then there's also a public side, so it's available to the public. And the public then also submits electronic data, both PDF report type things, but also electronic EDF, so laboratory concentrations. And what it does is it allows everyone to see what the results are and reports for any site that within the state. It's been pretty effective the last 5 years. Actually went into effect about 12 years ago. Slow compliance in some parts. But the main thing here is that it's published. Everybody can see it. This is what it was reviewed. And then for cases that did not meet the policy or that were deemed not to meet it, we were to develop the path to closure. And this was, as Ms. Farnock said, kind of saying, these are the steps you need to complete to get to closure. One of the complaints from industry was, well, we know what we have to do next, and they would do the next step, and then they would be told, well, okay, now you have to do this step. And they were saying, well, why didn't we know about that before? This was an attempt to get it out there so that everyone's clear, these are the steps. There is a bit of an issue here because at the very beginning, we really don't know what's at the site, so it's hard to predict what type of remediation or when remediation may be necessary. So, you know, the crystal ball's kind of fuzzy at the beginning. But as you move along, we can do a better job of predicting. So, as I said, this required the review of 700 sites, and it was not only just full case reviews, but we had to go out and get information. The first criteria in the policy was that it be within the service area of public water. Well, that wasn't something we usually tracked with sites, so we had to go find out where the public water was, and not only whether the site was in the public water supply, but the plume. We have a number of cases where the plume has migrated off-site, and are those properties, do they have public water supply? It affects development of that property. I mean, if public water supply is there, those properties can be developed. If it's not, they may be, their ability to put in a well could be restricted. So we needed to, you know, not just ask who you serve, but who you didn't and stuff of that nature. So anyway, but this was quite a task for staff. We met the deadlines, I'm happy to say. So, but it also has to be reviewed annually and updated. So it's a continuing task for us. This graph here shows, in blue is the Region 5 closure rate for the last 6 years. And then the, not red, pink, I guess, is the statewide closure rate. For this discussion, what I'm calling closure rate is the number of cases that were closed during a fiscal year divided by the number of cases we started that year with. All right, so simple math. The white vertical line is the date of the adoption of the low threat closure policy. So if you notice for Region 5, our closure rate started increasing before the adoption of the policy. Like I said, I was on the task force that recommended a policy be adopted. We recognize this is where we're going with this, and you know the criteria and the thought processes that we were going to have to implement. So we kind of got ahead of the curve on that, and so our rate of case closures increased a year or two ahead of time. statewide, the closure rate has also increased, and you can see we're about at the same point this last fiscal year, but it occurred later after implementation of the policy. And this is just for the regional boards. It does not include the local agencies. A couple things about the Region 5 graph, just for your information. You'll see that in the fiscal year that the policy was adopted, our closure rate actually dropped a little bit. I think this is due to the redirection of staff to doing these reviews. We had many cases that, you know, we have people that if you don't keep pushing them, they're stopping. And so when we stopped pushing for that bit of time, we didn't get things submitted. And so some of our closures dropped off.
How many staff do we have? Sorry to interrupt. But
This year, we're allocated 14.2 PY. I talk personnel years because we have staff that work multiple programs. And so we have probably 25 staff with some finger in the tank program, but I think the earlier presentation, it's...
so these reviews, I imagine they were quite different. Some were quite simple and some much more complex, but...
Right. And the stage at which the particular site was at was different. So the ones that were near closure, much quicker and simpler because not much left to be done. But
to be able to understand this, you started back in 08, 09?
That was just arbitrary.
No, yes, was that about 700 underground tanks back then?
No, 700 about at the vertical line.
Okay. So you're down to roughly
600 today.
600 now, right? Okay.
Right. And part of that, the uptick you see in this last fiscal year, the tank program is winding down. We close about 10 times as many cases as new cases come in. So it's a decreasing caseload. 2 years ago, legislation was passed that the state board was to certify the local programs. And so a number of the local programs statewide decided they were done with the program, and so they turned cases over to us. And that occurred, the first wave was June of 2013. And what happened when we got that case, that was about 80 new cases. And so that's why on the math, we've closed over 200 in the last 2 years, but we're only about 100 less. It's because new cases have come in from the local agencies. And one of the things we found was that a number of the local agencies, especially the small rural ones, they were not using the policy, they were not using GeoTracker, and we got files from them, and they were ready for closure. So it was pretty quick, and our closure rate bumped up there. Again, this is a closure rate. It's not numbers, it's a percentage of our caseload, and you can see state board or statewide and Region 5 were pretty much coming together there here this last fiscal year. Also want to note that of our closures each year, about 50% of them meet the criteria in the policy. The other half do not meet criteria for various reasons, but we're closing them based on an evaluation of the site-specific information, and we look at why did they fail the policy. A number of these may have surface water or a well that's near, but it's upgrading, and so we'll say, okay, that well is not threatened. So it fails the criteria of the policy, but based on site-specific evaluation, we agree it's ready for closure. And that would be using primarily the principles of Resolution 9249, which is the investigation and cleanup of spills and releases, and prediction of when water quality objectives will be met and everything, and basically allows us to close cases with contaminants remaining if we agree that the water will be able for use when we predict it'll be needed. In these instances with city water available, there's no expectation that the groundwater is going to be used for a number of years. We can talk to the agency and they don't plan to put in wells, so we can say, okay, that's fine. The resource is protected because it's not going to be needed for a while, and biodegradation is going to be assumed to occur.
What about the drought? Is that
That's a
game changer?
It could be. It's a matter because right now I think it's mostly the farmers that are being squeezed on that and having to get drill wells. But some cities, especially for growth, they may be moving from surface water supplies to groundwater, increasing their groundwater needs. So, yes, that's an unknown at this point.
But it's something that your office takes into consideration as it moves these forward.
Yes, we will talk to the water agency and make sure that they have no, plans in the book, so to speak, to use that to install a well in a certain area. But we're not trying to project for them what their needs are going to be in 20 or 40 years.
I guess my question is if the water table is shrinking and this water here is not projected to be needed for another 40 years, if the water table is shrinking, then that might be needed in 10 years or less. So I guess that the same amount of time might not be at play anymore.
That's true, but the policy, for the ones that are closed pursuant to the policy made some decisions on that, and so we abide by the policy. For the cases that do not meet the criteria of the policy, we do look and we will do things such as actually predict when water quality objectives will be made. Now, that's still, people looking at degradation rates and kind of predicting when it's going to cross a line. We don't know if it's going to go asymptotic or something, but we make a projection. And those we tend to be a little more conservative on, trying to see, we don't want to project as far away for that very reason.
So Brian, can I ask, even though we close sites, if we find that it's moving again or something, we can reopen a case?
Yes, any case can be reopened if it's found to have impacts elsewhere. But when we do close a case, that particular case is no further action necessary, no monitoring or anything. It's buttoned up and we walk away from it. So then it's looking at unexpected impacts down the road.
I have kind of a background question. I think this kinds of programs are really important for staff accountability, keeping the numbers and the graphs and making sure we're getting our work done. But also in this type of situation sometimes, can this or does this create pressure on staff to create the numbers at I can see this creating pressure on staff to move things forward that could cause premature closing, for instance, with respect to water quality. How do we just make sure or ensure that that type of activity doesn't occur? And I'm not questioning the integrity of our staff by any stretch, but I do know in some instances this type of numbers program can create negative impacts.
Right. At this point, we set our own projections for each year, the number of closures, and that's based on management's meeting with line staff and trying to look at your caseload and which ones are where in the process. We are not feeling pressure at this point to close cases just to meet numbers. If there's a situation where we believe it should not be closed, then it will go to state board for the determination on that, and they will consider, just like in an appeal, and so they will consider our point of view and the discharger's point of view on the matter.
I think that's a good answer. Thank you.
I would also add that there is a degree of pressure, as Shala mentioned earlier, being placed on the contractors who are receiving money from the UST fund. And that was certainly intentional for them to take a hard look at these cases and to really tell whether or not are you just doing monitoring for monitoring's sake? Should this site really be closed? Is it still posing a threat to water quality? So that certainly is a pressure that's being applied to contractors. And certainly there's a bit of a healthy tension on just a couple sites. I'd say it's the vast minority of sites where there may be, some allegate maybe the money's run out and the contractors are saying close it. State board staff might be taking a neutral position, and regional board staff might be saying no, a little bit more work needs to be done. But there is a little bit of pressure there. I would say the pressure is mostly on the contractors to justify why they should keep a case open.
Yeah, and I like the term healthy tension.
Okay, now it's not working for me. There we go. So looking forward, we're going to be continuing to use the low threat closure policy, obviously. As I said, the requirement to review cases and attest to whether it complies or not with the policy is an annual review. And so now we're starting our third review. So there was statewide, you saw that surge of cases right after the policy met. We've kind of worked through those now and run them through that filter. So I think our closure rate is probably going to be leveling off, or it may even drop some because we had what may be considered a backlog of cases that when the policy came out, we weren't expecting to be closed, but because they meet the policy, we're closing them. So you get that surge. But we've gone through this process now. We're starting our third reviews. So I think we've caught most of them. About 1/3 of our caseload, so 200 cases, are in what we call site investigation. So they're still installing monitoring points and sampling and trying to develop this site conceptual model of what the release looks like and whether it's stabilized. Those cases, as they complete the investigation, and that's actually increased. The policy stimulated some of these RPs who had been maybe not as proactive to get their reviews done. 4 years ago, we probably had 400 cases that were still in site investigation. So we've cut it back quite a bit. And so once the site investigations are completed, those are the ones that are complying with the policy now when they complete their documentation saying, we meet the criteria of the policy. The remainder are these more difficult cases. They either got impacted supply wells, vapor threats, discharges to surface water, something that requires much more action on both the responsible party and on staff. And so our more difficult cases is what we're ending up with. And you would expect that distillation to occur. So that completes my part of the presentation. Any more questions?
Any further questions? Thank you.
Okay, I'd like to introduce Duncan Austin. He's the program manager for our site cleanup program.
If I can say something while he's transferring, that number in 2009, Brian and I, and at the time Rick Moss, had many discussions about the underground storage tanks because some of them had an extra long life period. And Brian really was very proactive in working as a program manager to try and address some of those older cases. And I think that's why you saw the House Region 5 was a little more progressive than the other regional boards in trying to allow our staff to focus more of their time on those that were considered more higher threat and a concern to the public or the environment. So Brian did an excellent job of being ahead of the curve in terms of closing our sites.
Thank you for that comment, because Brian, I was impressed by how proactive you've been, and you and your staff have been on this, and just keep up the good work.
Yeah, I counted 28 listed in your EO report of closures, this report. And one of the things going through this presentation has been really useful for me, and I think it would be helpful just to put 1 or 2 or 3 paragraphs in the EO report, just so some of this is on record where the public can read it too.
Yes, Duncan, go ahead.
Okay. Good afternoon, Chairman Longley and members of the board. I'm going to provide a summary of how the low-threat closure policy might apply or its effects on the site cleanup program. But first, because it's rare that the cleanup program issues come before the board, I've been asked to take this opportunity to provide the board members with a brief overview of the program before I do that. So from a staffing perspective, I think we're right. No, we didn't move. There we go. From a staffing perspective, the cleanup program employs about 29 full-time staff and has 16 staff members that are partly funded by the program. The allocations of the staff between the offices is shown on this slide. And as shown on the slide, you can see that the majority of the cleanup staff are based here in the Sacramento office. So nearly all the sites that are worked on by the cleanup program staff are the result of legacy pollution that was caused by historic chemical handling and disposal practices. Those practices resulted in the pollution of soil and groundwater. And the cleanup program's work is focused on cleaning up the polluted groundwater and cleaning up waste that threatens to continue to pollute the groundwater if it's not properly addressed.
Duncan, I got a question for you.
Certainly.
And maybe this isn't the time to fully answer it, but I think sometime in the future. You know, the Aerojet site, I swear, has been around as long as this board's been around almost. And I guess we'd like to, at least I would like to catch up on where we are on Aerojet. You know, if there one thing has been constant while I've been on this board since 1989, it's Aerojet. And almost the same thing can be said about McClellan.
Right, and you can see I've broken them out.
Exactly.
They sort of represent their own thing.
But maybe today's not the time to do it, but let's make a check mark by that.
Okay.
Thank you.
Certainly. So anyway, the majority of the sites in the program are known as private sites, we call them. Private sites include numerous different types of sites, such as railroad facilities, dry cleaning facilities, pesticide, fertilizer manufacturing and handling facilities, wood treating facilities, and petroleum product handling facilities as well. So several staff members, as you can see on the slide, are devoted to single large cleanup projects, including Aerojet, but also the Sacramento Rail Yard, Lawrence Livermore National Laboratory. And the work on the private sites comprises about 2/3 of the efforts of the cleanup program. So I'd like to just note that private sites are subject to cost recovery. I mean, we had a budget presentation a little earlier. And so in other words, our staff tracks the amount of time that they work on their sites, and the parties responsible for the sites are billed for that time. So all the costs of my staff that work on private sites comes back in the form of bills that go out in the...
And Aerojet would be considered a private site?
Yes.
Even though you haven't broken apart.
Absolutely. So another group of sites includes the region's legacy and active military facilities. While much cleanup work has been completed at a lot of these facilities, such as the former Sac Army Depot and Mather Air Force Base and Castle Air Force Base, there's still a significant amount of ongoing cleanup being performed at Beale Air Force Base, McClellan Air Force Base, and other facilities as well. The DoD portion of the program is funded by a grant, so that also is not on the state budget. And the grant operates on a 2-year planning cycle, and we just started into a new planning cycle this year. So the cleanup process involves performing a site investigation, preparing a cleanup plan, implementing the cleanup plan, also known as going into the remediation phase, and finally closure of the site. Achievement of site closure, which is a determination that no further action or no further cleanup actions are necessary, typically involves a period of monitoring to establish that the remediation has been effective. The performance objectives for our program are based on moving sites out of the investigation phase and into the remediation phase, and then our other performance objective is achieving site closures. So you can see on this graph, this is the cumulative number of remediation starts and site closures we've achieved over the last 4 years.
About how long does it take from, I guess, identifying a site to closure on average or in general?
Yeah, it's
I know it could be
highly
very variable.
variable. You know, for instance, cleaning up the groundwater at Aerojet will, you know, but other sites where you might get in, like say a hydraulic lift is discovered to have hydraulic contamination underneath of it, maybe in the groundwater. You could dig that out, remove the water from the hole, and you might finish that in 6 months. So it totally depends. And, you know, that's kind of the thing of these performance objectives is we get these counts, but some of them are extremely difficult to get, and some of them are not very easy to get.
So the answer would be from months to centuries, is that correct?
Yes, forever. Okay, so petroleum sites in the cleanup program. I'm going to give a short presentation on how the implementation of the low flood closure policy might affect the cleanup program. Excuse me. Like the underground storage tank program, the cleanup program includes a number of sites where the contaminant is only petroleum. Those sites are primarily associated with above-ground storage tanks, pipelines, and natural gas dehydration facilities. So of the region's nearly 600 private sites, about 25% of those can be categorized as petroleum-only sites. So about a quarter of our sites are petroleum sites.
Are any of these petroleum sites associated with petroleum production?
Some, yes. Down in Fresno, you know, there's a couple petroleum sites. We don't have a lot of refineries other than that one in our region. A lot of them are associated with petroleum handling, bulk facilities where it would come from the refinery, offload near the river, basically, to big tanks, and then would be distributed from there. So depending on your definition of production, they are.
Okay.
They are.
We talk about pipelines, of course.
Pipelines, obviously.
Earlier we had the discussion about the pipelines associated with service stations, but we know the oil companies have these huge pipelines going back and forth.
Yeah, we have pipelines by Shell and Chevron. A lot of these historical, they've been closed down since the 70s and even earlier, that run basically from Bakersfield all the way up to the Bay Area, right through our region.
And are there issues with those?
They all leaked, yes. Yes.
Good, thank you.
Okay. I think I'm on this slide now. So based on a survey of our seniors and our key cleanup staff as to what would the effect on our caseload be of implementing the low threat closure policy in the cleanup program, we found that about 27 cases would be closed in the Sacramento office, about 10 site closures in the Fresno office, and about 13 site closures in the Reading office.
I'm sorry, this is if we apply the policy as stated. This is not the supplemental thing that we were talking, that was asked of us, the non-USD. Right.
Right, and the main reason is the difference is in our program we do a period of monitoring. We clean up the site, we do a period of monitoring to establish a downward trend, and then, you know, like we used to do in the tank program, we would predict when water quality objectives would be met. In some cases, the rate is very slow. In some cases, it's very bouncy. So we have a number of cases that are sort of sitting in this monitoring phase. The low threat closure policy would allow you to just close those sites. Just assume it's all going to be good. It's petroleum. It's going to degrade. It's going to take time. You're in a public water supply area, so you know you got time, and so we would just close those sites. So in summary, there are a number of cleanup cases where the pollutant is simply petroleum, and therefore the policy could be applied. My staff estimates that about a third of those cases would be potentially closed by implementing the criteria contained in the low threat closure policy. I would also like to note that for cases that do not currently meet the policy, for example, sites that are undergoing characterization or maybe we're still removing free product, once those activities are completed, application of the low threat closure policy would greatly expedite the closure of those cases. And that's really all I have for you, unless you have questions.
I'll let somebody else go first because I'm still working on.
Go ahead, John.
I was just going to ask a general question. The idea that Pamela brought up that there's a few non-UST cases that, well, I guess I sort of biased the question. How many non-USD cases are we talking about? I actually think, you know, the what I've heard is that if the criteria is all the same, then certainly the application of the policy seems to fit the procedure. But I was just wondering what the scale is.
In terms of numbers of cases, I think we have about 50.
Okay.
You know, or about a third of our cases.
I just want to make a comment. You do your billing cleanup of these by site, and then there's a responsible party that is billed for that staff time.
Yes.
And I'm just wondering, and maybe I shouldn't ask the question, but on our ACLs, how come we can't do that and bill
I can't
our staff
answer that
time that
question.
works on those?
I can answer that. Duncan and his staff have a very accurate accounting system. And why the state board has done that with the ACL issue is because we lack a very accurate accounting system of staff time. It was just always based on an estimate or a guesstimate of how much time. If we could have something that could be auditable by auditors, like they do with the recovery process, then we could do that. But right now, the state board doesn't have that type of a system for ACLs, and that's why they've recommended not recovering staff costs.
We can't have one for just Region 5 then? I mean,
Well, we have
putting
to have-
that together may be more than it's worth.
Well, we have to get permission. That's exactly what they said. They would cost a lot of money to develop a system that would meet the level that's needed for auditors.
Not only that, but you know, as an attorney in private practice, billing is the worst part of everybody's job. So
Yeah, ask my staff.
yeah,
They
so
keep track of everything they do,
That's
you know,
right.
in detail, so that when questions are asked, we know exactly what they were working on and how much time they spent.
Yeah, and that's a hard,
Yeah.
you know, way to live.
It would be on $100 a meeting, but.
Point made.
I just have one other
Okay.
comment, just for my colleagues on the board. It's interesting, in the mid-1990s, I was involved in a redevelopment project in Davis at 5th and G Street, which both had a dry cleaner and petroleum products. Yeah, and I worked on that, and my job as part of the development team was to ensure that the city of Davis accomplished what they said they would accomplish for the Central Valley Water Board. So I tracked their work and the water boards, and here I am as a result of that work. So anyway, that's just an aside.
Well, and I have two things to say. One is this was how I got started on water board issues, and I think I may have actually worked with Mr. Duncan here. I don't want, well, you know, anyways, my first venture with the water board had to do with an underground storage tank from a gas station. So I think that's still an active site. So this might be one that goes on for centuries, like Carl talked about. My question is, going back to your second slide, you talked about how staff is divided between Sacramento, Fresno, and Redding. And then on a subsequent slide, you talked about how many open cases there is in different places. And I see that the resources are not allocated in the same percentage as open cases. Is that because Sacramento acts as a hub and everybody from Fresno, you know, sends their cases here, or why is that?
It actually, if you look at the these particular cases, distribution is based on petroleum cases. So you'll see there's more petroleum cases in the Fresno area. They work on a lot of the pipeline sites, and it seems like there's more petroleum cases down in Fresno than there is in Sacramento, given the staff. But in total, when you add in the dry cleaners, we obviously have more dry cleaners here in Sacramento than any other place in the region. So that staff distribution is kind of based on cases and workloads in those regions. It's just this particular breakdown shows there's kind of more petroleum cases in Fresno than elsewhere.
Okay, yeah, because I saw that.
Yeah,
you know,
doesn't seem fair. We should be getting all the money.
It doesn't seem fair. It seemed like, you know, Fresno had half of the Aerojet. He's saying Aerojet over here.
Right.
It just seemed like, you know, 25 full-time staff in
Right.
Sacramento and only 4 in Fresno for dealing in a geographic area like that with these types of cases
Yeah.
didn't seem
Yeah, this is-
equitable. But if it is equitable,
Well, this is a reflection of the location of the petroleum sites. When you look at the whole program, it's more cases here, way more cases here.
Okay, all right.
McClellan and Aerojet and Lawrence Livermore and the rail yards, and a lot of these cases require full-time staff just for one case.
all right, well, I appreciate the explanation.
Sure. Okay.
We do look at that resource distribution every year and analyze it and to determine where the best places for resources need to be.
Good, thank you.
Any further questions or comments? Thank you very much.
You're welcome. Thank you.
Very good report.
So this is more than just a report, though. I'm seeking some guidance from the board.
Yeah, so I think I spoke already, but well, in fact, I know I spoke already, but my view is that if the criteria developed in the policy is applicable, I would hate to go through the extra work and bureaucracy and expense of the discharger if technically it was essentially the same. I mean, if on a piece of paper it looked the same as it did somewhere else, it just the source was slightly different, I would not be opposed to using the streamlined approach.
Well, it would seem to me, and please correct me if I'm wrong, but it would seem to me that the 8 criteria you're talking about is making the assumption when it gets to this, using that criteria to the low threat level you're talking of, that you've described, that residual, low threat residual, will be over time dissipated probably by biological processes. Is that correct?
Yes.
So remediation is continuing with this non-threatening residual.
Right, it's a non-active
Not-
remediation.
Exactly. And we know that if you have an active remediation, each succeeding drop you take out, the cost for that goes up exponentially.
Yes.
And given that we have higher threats from various sources that we have to address, and I think it is very expedient, in my opinion, it is very expedient for us to follow the criteria closely and remove staff oversight to the level it has been from those low threat cases and have those staff working on other issues before this board that are much more pressing. My thoughts.
And if I could make one comment, I think we've got 9249 is really the policy that even the USTs were being closed under before the low threat policy came out. And that generally covers all cleanups under that we issue cleanup and abatement orders for. It also implicates the health and safety code provisions that USTs are cleaned up under. And 9249 has some vague language. First of all, it lays out the benchmark that you're going to try and get to background, which isn't water quality objectives. It's even better than that. Restore it 100% of the way to what it was beforehand. And if you can't, do the level that is best technologically achievable. It also has the metric that says that the discharger has to show that water quality objectives are going to be met in a reasonable amount of time. What the UST unit did at the state board was take a look at petroleum sites in particular, UST sites in particular, and say, here are the models and here are the metrics which we're going to use to determine reasonable amount of time. And so it kind of short-circuited those two processes as far as 9249 was concerned. And so we have a policy of general applicability for UST sites. And I think that was built very solidly on the foundation that, look, these aren't exotic constituents. Petroleum is very widespread. We know a lot about it. We know how it degrades in nature. And we can make these conclusions based on these models that might not be applicable for something like a more exotic pesticide formulation or some other constituent that we really don't know a whole lot about. So for the non-UST sites, even though we don't have a policy of general applicability, because that would be an underground regulation, we can still bring over those models and bring over those justifications into a case-by-case consideration for those petroleum sites. While they might not be a UST site, they might look a heck of a lot like a UST site in terms of what's in the ground. So I think what Pamela is asking for from you today is a thumbs up on saying that given the technical justification that's come before you today, that makes a heck of a lot of sense. Let's focus the board's resources on getting cleanup of those, dry cleaner sites that don't fit under the policy, those more exotic threats to human health that do sometimes consume a whole lot more staff time.
You restated my position more eloquently. Thank you, Patrick.
And I agree, and I think that it's important for the people who are, for the public or for entities that are going to be subject to these regulations, to at least know what the end is going to look like, and to have a project start with the end in mind is important, because when I worked for the city of Merced, it felt like it was a moving target. I never knew what the end was going to look like, and just working and trying and working and trying and never really knowing if and when and what it would look like when we got to the end was really disheartening. It just felt like you were always trying and never knew when you were going to achieve it. So I think that that's important as a policy, certainly for staff time allocation, but also for the benefit of the public and the people who are going to be subject to these regulations. So I like the general principle of this.
And I would say that there would be a greater level of risk in pushing the envelope with this policy at non-UST sites, but we do have representatives from State Board here saying that while they won't make a site, site by site, go ahead and do it, generally they're very supportive of that concept. And frankly, it was only because State Board was concerned about mission creep that they didn't include non-UST sites in the UST low threat closure policy.
So let me ask you a question, Patrick. I'm sorry, let me just interrupt and then. Patrick, would it be appropriate for a motion, or what kind of statement are you expecting from this board? And I'm just looking at process.
I think we can get your general sentiments is good enough without a specific motion here, because we didn't notice this as we're going to take specific action.
Okay,
so
good. Go ahead, Bob. I'm sorry.
That's right. I just wanted to say one of the stakeholders in this was the Orange County Water District, who manages and monitors probably one of the most best managed groundwater basins in the world. And I'm happy they're in that process, and if they're confident of this process, I think that also lends a lot of credibility to this. The other thing I really like about, and I agree with our board sentiments and what you said, Patrick, is this ability to be able to focus our staff on our priority cleanup issues. I think that is a benefit that's incredibly important. And I'm confident our staff won't let things slip through on this policy, but judiciously use it to get work done and be able to focus on the priorities. So thank you.
Thank you very much. Jenny?
Yeah, I agree with what Bob said, that, I think this policy in general, I appreciate having a streamlined policy that, people know what to expect when they're going in. And it does help, hopefully, relieve some burden from staff to redirect them to other issues that are very important as well. You mentioned, Pamela, that not everyone is in agreement that we should, expand this to non-UST cases, and I just wanted to know what maybe some of those sentiments are from staff.
Oh, can't turn. Thank you. Well, even within the underground storage tanks throughout the state, there are still staff who don't agree with the policy, and I don't know the exact details of them. I just know that there are some staff who just by nature have a difference of opinion of the studies and research done by Lawrence Livermore and others on degradation and the time it takes. It wasn't just a guess; it was based on some informed information on how long it takes to degrade, naturally degrade, remediate in the ground. And it's just typical. We have staff who have differences of opinions, and we have wonderful staff. I'm not against staff or the fact that they have a difference of opinion, but it really, at this point, it was a board call. I think every item we bring to you, I could provide you a couple of staff who don't agree with the recommendation. And so I can't, that's just the nature of us with all the different scientists and technical people we have. There's just a general difference of opinion.
I would concur with that. I would also add that under the low threat policy, which that's our marching orders. I mean, staff disagreement aside, that's our directive. It does result in leaving a lot more pollution in the ground. The studies are solid that pollution will naturally attenuate, but I think that there is a gut reaction, and we don't base our decisions on gut reactions, but there is a gut reaction from some folks saying, hey, we're leaving some petroleum in the ground. There is, even though it's a minute threat, there's still a threat there. But again, that's not up for discussion anymore. That's been the direction from the state board.
Thank you. Any further comments by board members? Do you have our sense of direction?
I certainly,
we concur.
Yes,
certainly
sir.
appreciate
Thank
it.
you.
We concur. Okay. With that said, it is now 12:04. The board will be meeting in closed session.
We will be meeting under Government Code 11126E to consider initiating litigation under Water Code sections 13262, 13264, and 13386 for discharging without a permit and without filing a report of waste discharge. And I believe David Koop also has a matter.
Just a brief discussion. So under the closed session and on the agenda announcement, under item Q, under litigation filed against the Central Valley Water Board and State Water Board, the board will be meeting briefly to discuss Atlantic Ridgefield versus the Central Valley Water Board.
And just to be clear, we would need to come back and gavel the meeting closed after the closed session, even though I fully anticipate it will be a completely empty room, just to report on what we did in closed session.
Thank you, because I was going to state that I will come back to this room and continue, not the meeting close, continue the meeting till tomorrow.
And so on that note, can I just be clear what is off the agenda for tomorrow? Do we know?
Tomorrow,
it's in your package.
item 16 it's been pulled entirely from the agenda.
I have, yeah.
And then we have two items, items 17 and 18. The parties who were contesting the orders are no longer, they're uncontested items now.
Okay,
So,
that's what I have, thank you.
Dr. Long, I don't know if this is the appropriate time, but
sure.
There's also on the agenda announcement, it's item 22B that's on the uncontested calendar. That item's been pulled as well for consideration at this board meeting.
Okay, and we'll re-announce that tomorrow. Thank you very much. We'll go into closed session and in the boardroom.